promotion of human rights, thanks to the common interest and pact of states and societies to give life to the American Convention and the Democratic Charter. Since 1959, hundreds of professionals have passed through this institution, and thousands of individuals, groups, and peoples have turned to the Commission seeking protection, justice, and reparations. We celebrate 65 years of history with more than 100 site visits, with their corresponding reports following those visits, more than 1,000 precautionary measures, more than 750 reports on the merits, 220 friendly settlements, and 377 cases referred to the Inter-American Court. All of this work with victims as the central focus and our priority. Before we begin as well, let me say that to ensure that the hearing is inclusive, we ask all participants to begin their presentations by stating their name, position, and the organization or institution you're representing. Subsequently, each time you take the floor, we would ask that you repeat your name at the beginning, and this is to accommodate the visually impaired who might not be seeing the names, but that they can at least hear and identify who is speaking. Likewise, we'd like to remind you that the audiences have Zoom subtitles available. Each person can activate them directly from their computers and choose the display size. They are also available for those who follow us through our IACHR channels. And as well, I will be speaking myself, and Commissioner Demise will be speaking in English, but there is, as you, translation available, and we hope it's at an appropriate pace. Before we start the actual hearing, the timing this afternoon, our process will be like this. We'll begin with representatives of the civil society, and you'll have 20 minutes. And then over to the state, and you will have 20 minutes as well. And then to the country representative of the OHCHR in Honduras, who will have 7 minutes. Then we, commissioners, will have 20 minutes to interact with you. And then we turn it back to civil society for a further 10 minutes, the state for 10 minutes, and then we close. So without further ado, let me invite the members of the civil society to give their presentation. And the clock has started at 20 minutes. Thank you.
Buenas tardes, soy Catalina.
Good afternoon, I am Catalina Carbonell. We salute and we thank this space. We also salute the representation of the state from the Office of Honduras for the Human Rights, and those who are here with us from the indigenous territories, Black and Campesinos in Honduras. Before we begin, we request the pertinent guarantees be granted so that there will be no reprisals from the state and third parties against those who participate in this hearing, as well as those as their family members and organizations. The evictions affect all these indigenous communities.
Judiciales eficaces para hacer frente a estas violaciones.
If they could speak a little slower, that would help for the interpreters. They're reading at breakneck speed.
Okay.
So forced evictions affect the indigenous, Black, and Campesino communities in Honduras. This is worsened by the lack of administrative and legal mechanisms in order to face these violations, as well as the criminalization and state violence against the members of said communities. This problem is one of the root causes of the rise of poverty, internal displacement, and migration in Honduras, with particularly serious consequences for children and women. The indigenous peoples, Black and Campesinos, who live and work their ancestral lands and protect the common goods of their communities, instead of being protected, they are the ones who are in the crosshairs of the state, accused of usurping by third parties. May we request her
Y cedo la palabra a mi compañera.
I apologize again. We're not getting the translation. They're asking if you could kindly speak a little slower.
Oh, okay.
It's very difficult for them to keep up.
Hablar más despacio. ¿Sí? Okay.
Buenas tardes, ilustre comisión.
Good afternoon, illustrious members of the Commission and State. My name is Kenya Oliva of the Bufete Justicia para los Pueblos. We have accompanied any number of cases that have resulted in illegal evictions and forced displacement of indigenous peoples and peasant communities. In this context, it's important to note that although Honduras has ratified ILO Convention 169, compliance with it is practically null when it comes to protecting rights in these situations. Dozens of persons who are members of community resistance initiatives have been accused of usurpation because they have legitimately spoken out as citizens against mega projects that have not been consulted with the communities impacted. Some of the cases are Patuca, Jilamito, Pahuiles, Retoca, and Guapinol, among others. This crime of usurpation has also been used against the indigenous peoples for merely occupying their own ancestral lands. Among the cases we've documented are Rio Bonito, Tierras del Padre, El Cacao, and Potrerillos. All of these are lands of the Lenca people, the cases of the Garifuna people, including Guadalupe, the community of Cristales, Rio Negro, and Punta Gorda, and in the case of the tribe of Agalteca, of the people of the Pueblo, of the Tolupan people. In some of these criminal proceedings, the state carried out violent evictions using the legal argument established in Article 227 of the Criminal Code, which was recently repealed, and Article 13 of the Code of Criminal Procedure under the name of neutralizing the effects of the crime. Evictions are generally ordered and carried out against the entire community, even though the number of accused may be very few. No prior notice is given, which annuls the right to defense, and when victims are able to realize the situation ahead of time and raise challenges, they are not resolved diligently. On 25 June 2020, a new criminal code came into force. It substantially reformed the traditional criminal definition of usurpation and usurpation of waters. This new criminal code was amended fraudulently on 7 October 2021 by Decree 93/2021 due to pressures by the Honduran Council of Private Enterprise, which is a lobbying network of the business elite of the country, and they had clear interests in guaranteeing their own access to territories that would be key for extractive businesses and other businesses. The reforms to the criminal code are Article 378 and 613, and Article 378A is added. The decree also amended the Code of Criminal Procedure, Article 54, and also 26B and 224A were added. All these reforms had the purpose of aggravating the crime of usurpation so as to facilitate evictions from the territories. It's important to note that in addition to criminalization and forced displacement, there's been documentation of physical violence, surveillance, and smear campaigns to try to neutralize and disarticulate the community struggles. Thank you, and I now give the floor to Juan Garcia of the Indigenous Council Lenca de Rio Bonito. My name is Juan Garcia Vasquez. I'm 80 years old. I am here in representation of the Lenca people of Rio Bonito. I was imprisoned in 2023, convicted of the crime of usurpation. In June of 2023, 52 of us were violently and unlawfully expelled from our land, and this included children, women, and older persons. Though Honduras is known for the sluggishness of its judicial and administrative proceedings, in the case of Rio Bonito, the Attorney General's office and the National Police took only 4 hours from the lodging of the claim to the eviction. In addition, on that day, 4 people were arrested on aggravated usurpation charges. We've not been able to go back to our land, and we have been living in a precarious situation for almost 9 months. Before that dark day, we were a completely self-sustaining community. We cultivated our collective lands for our own subsistence. These lands are now being harmed and cleared by persons who only seek profit without respecting the special relationship between the land and natural resources and our values, uses, traditions, and cosmovision. We lost our homes, our crops, our cemetery, and our church. Our children lost their class, their school. The National Police shut down without any major arguments this week. The police ceased dealing with our complaint that we presented against those who evicted us, and since August 14th we have been waiting for the Supreme Court to accept an appeal that we have presented. We're about to disappear as a community. Thank you. I now yield to my colleague Saul. I am Saul Nunez, and I represent the 3 communities that make up what is known as the Lenca Potrerillos territory. 11 of our colleagues have been criminalized by using the criminal statute on aggravated usurpation. Our case points out the irregularities engaged in by the state to benefit interests of third persons. For 4 of the persons are not even from our community. Those who were criminalized, 4 of them are not even from our community, whereas 2 others have been accused of usurping a different property. When we went to the courts, they treated us with racism. The judge called us indios. They accused us of judicial coercion. They blackmailed us with more than 70,000 lempiras, and said that and they said that it was assured that we would never win back our lands. In 2020, the National Agrarian Institute issued the property titles to us for those lands, but mysteriously this proceeding ended without us actually receiving the deed. And now a third person is claiming that those lands are his. We did not know about the proceeding, and we even began to pay this person who promised to secure papers in our name. Last year, a court ordered the eviction of the entire community, although this did not happen because of the legal actions we filed. Thank you, and I now yield to my colleague Marlon Castro. Good afternoon. My name is Marlon Castro. I am the chair of the board of directors of the Lenca Indigenous Council of Tierras del Padre. For almost 8 years, our people have been criminalized and threatened with eviction on a constant basis after the Attorney General's office accused 11 persons of the crime of usurpation to the detriment of a real estate company called 21st Century Inmobiliaria Siglo XXI S.A., owned by Mario Facuse, a landowner from one of the economically most powerful families in the country. The accusation was a motive for the judiciary to order that we be evicted on several occasions violently, which provoked permanent stress and a serious psychological blow to our children and entire families who love their homes, their land, and their community. We were able to address the situation because our people are united, and we had the support we needed. Despite this, there was infiltration, dissemination of false information, and terror by the state security forces, which has had a profound negative impact on our families. Even though a short time ago the Supreme Court put an end to these threats on ruling on an appeal in our favor, it's important to note that many indigenous communities do not have access to the support necessary for waging these battles. In addition, there are structural barriers and flagrant racism and classism that is harmful to the indigenous peoples. Many children continue fearful that their loved ones will be taken away, that they'll be thrown away out of the only home that they have known. Although we have won this battle, we know that the war continues. We ask ourselves constantly, will there be What will come next? Will there be a civil lawsuit? Will there be violent reprisals? We cannot live in peace. We are a humble people, but we have dignity, and will never abandon our holy land, our sacred land. Thank you. And with that, I yield to my colleague, Reynaldo. Good afternoon. My name is Reynaldo Dominguez, and I am the chair of the Board of Directors of the Board of Directors for Water of the Guapinol community, part of the Municipal Committee for Defense of the Common and Public Properties of Tocoa. Together with 40 members of my family, we have been internally displaced since my two brothers were assassinated last year as reprisal for my activism to protect our rivers and lands from the illegal mining mega project of a company called EMCO, owned by Ana Facuse and Lenir Perez. Even though we are beneficiaries of precautionary measures 137-2023, the state has not even communicated with me since my brothers were assassinated in January and June of 2023 to implement measures. In 2018, we installed the peaceful encampment for water and life to reject this mega project. 88 days later, more than 1,500 members of the security forces, state security forces, brutally evicted us. We were evicted, and 32 of us were criminalized, accused of the crime of usurpation, among others. As a result, 8 defenders spent 2.5 years in arbitrary detention. The Attorney General's office carried out the eviction even though there was not a firm judgment. Years later, it was shown in the courts that there was never any act of usurpation, but the harm was already done. Despite our criminal complaints for environmental damages and the criminal acts of the company, there's not been progress in the investigations. But when the company lodged a complaint against us, the Attorney General's office moved nimbly, using evidence that had been invented by the company to justify our eviction and criminalization. In 2020, the Working Group on Arbitrary Detentions of the United Nations ruled that the state should investigate those responsible for the arbitrary detention and make reparation for the harm to the defenders who had been criminalized. Yet, to date, there's been no progress whatsoever. Moreover, the company continues operating, and the threats continue. Though I continue to be committed to defending our rivers, I must say that no one is prepared to go through what my family and I have gone through. What is sad is that many young people from our community have also been forced to displace, both internally in Honduras, and they've also gone to Europe or the United States due to the very same threats. Criminalization and forced displacement are ways to try to hush us up and to weaken our legitimate struggle on behalf of our common properties. Thank you, and with that, I yield to my colleague, Melissa.
Parece que el audio no.
It seems that the audio isn't working at their end. Melissa? Can you hear us? Can you try to speak? It seems they're not hearing us. Well, let's go to the prayers for relief then.
Yeah, so what if we may, we will, Melissa's speaking, let's see, but we don't hear anything. So we can try to see if the...
I'm afraid, Melissa, I'm not sure if you're hearing us, but we're not hearing you. maybe you could tell her that there's time in the reply, so they can try to sort this out now. And if you have any other speakers, you have 2.5 minutes left.
Okay. Sí, voy a hacer las peticiones.
Very well. I'm going to state the petitions on request of the participating organizations. We call on the National Agrarian Institute and to urgently resolve the titling of land in the case of the Lenca Indigenous Councils of Tierras del Padre, Rio Bonito, Potrerillos, and of the territory of Guaira Lee in the community of Punta Gorda, that the Property Institute approve a protocol that guarantees the causes of inalienability of the ancestral titles of the Garifuna people so that no public deed in the possession of third persons that derives from ancestral titles be registered. We ask the National Congress to repeal urgently Decree 9321. The judiciary, well, we ask them that in any proceeding related to the ancestral lands, whatever the procedural position of the indigenous peoples, guarantee international legal provisions on collective or community properties. That the Constitutional Chamber urgently resolve the constitutional motion presented against Decree 93-2021. That the judiciary refrain from ordering eviction until such time as there is a firm judgment, and until there is, and that it be ordered that a judgment be carried out that respects the and guarantees the principles of the United Nations on evictions. We ask the Attorney General's office that through a proceeding that guarantees the full participation and free, prior, and informed consent of the indigenous and Garifuna communities impacted, the Attorney General's office at the highest level should send instructions to investigate complaints of usurpation filed by third persons and that they be related to and that are related to ancestral lands of indigenous peoples. Well, it should be required that there be coordination with the Office of Special Prosecutor for Ethnic Minorities until such time as protocol is adopted to investigate the complaints over usurpation in these cases. This investigation should be carried out in conjunction with and in consultation with the indigenous and Garifuna peoples who are impacted, fully carrying out the international obligations of the state. Furthermore, it should investigate on a priority basis the complaints filed by the indigenous peoples over the dispossession of their lands, whether through usurpation or purchase contracts that have proceeded in irregular manner. Thank you very much.
Thank you very much. And I see Melissa's still there, so please remind her that at another stage she may be able to speak then, so maybe they can try to sort that out. So I now give the floor to the representatives of the state. You also have 20 minutes to make your presentation. Over to you.
Distinguidos miembros de la
Distinguished members of the Inter-American Commission on Human Rights, distinguished petitioners, members of the audience, on behalf of the State of Honduras, we extend our remarks of salutation in the occasion of this hearing related to the forced evictions of Black, Campesino, and indigenous communities. I am Andrade Rodas, and I am accompanied by an interinstitutional delegation made up by the Secretariat of Human Rights, the Office for Social Development, the Department of Security, the Department of the Presidency, and the National Institute for Agriculture as part of institutions related to this topic. On behalf of the state and the government, led by the first woman president of Honduras, it is Xiomara Castro Sarmiento, it is my duty to inform you the commitment of the President and her cabinet with the promotion, defense, and respect towards human rights of everyone, especially the communities and the Garifunas, the ancestral peoples of our country, with whom we acknowledge that we have a historical debt that has to be paid, which we have committed to honor. In this occasion, the State of Honduras is going to address the aspects mentioned by the representatives that requested this hearing, as well as other general aspects about forced evictions in Honduras and the commitments acquired by the state and the current government in order to prevent the illegal use of said mechanism. Before addressing this topic, it is important for us to reiterate that the government of Honduras has a strong commitment of ruling to the service of the people, taking the necessary and positive measures to pay special attention to those groups that historically have lived in conditions of vulnerability. In this regard, I would now give the floor to the Secretary of the State for Security. Esteemed Commission and public in attendance, I am Hector Gustavo Sanchez, Secretary of State for Security. Continuing with our presentation, we would like to inform to this Honorable Commission the following. With regards to the actions adopted by the State of Honduras related to the forced evictions, on March 20, 2023, it was published in the National Gazette the Law for the Prevention, Attention, and Protection of Internally Displaced Peoples that seeks to prevent internal displacement, also to address, protect, and to provide humanitarian assistance to people or group of people that have been forced to flee or leave their homes or the places where they normally live. Article 39 of said law sets forth the national policy for prevention of forced displacement. In this framework, the Interinstitutional Commission has the obligation to provide protection to internally displaced people, and they have to design in 2 years the national policy to prevent displacement, and they have to establish measures that will allow us to prevent the arbitrary removal of these groups, the Lenca, Garifuna, blacks. In the same way, we inform that in order to achieve full efficiency of this law, it is important to establish a set of regulations that will regulate specific aspects for its functioning. Said regulation is currently under construction by the Interinstitutional Commission for the Protection of Forcibly or internally displaced people with the technical assistance from the High Commission, the Office of the High Commissioner of the United Nations for Refugees, also with other institutions and with the academia. On the other hand, the Constitutional President of the Republic created in the National Defense Council the National Commission of Agrarian Security and also Access to the Land, which is responsible to decrease, to stop violence and criminalization against campesino communities, Garifuna, Lencas, and other ancestral peoples. Within the framework of said creation, the Supreme Court of Justice has emphasized that the executions of evictions must be conducted in fulfillment with the general observations issued by the Council of Economic, Social, and Cultural Rights, which mean that the state have to guarantee human rights, emphasizing that evictions should not be unfair or illegal. In this regard, the Supreme Court of Justice has created the protocol for cases of eviction, highlighting the duty of the state with regards to groups of people in situation of vulnerability, warning that said measures of forced evictions, particularly in this case, in the case of vulnerable groups, have to follow the guidelines established by the Committee for Economic, Social, and Cultural Rights in fulfillment of international obligations contracted by the state, specifically those set forth in number 13 of the General Observation number 7 on the right to a dignified housing. The Supreme Court of Justice believes that every eviction has to respect human dignity so that human rights are respected, and thus guaranteeing the minimal use of force. Regarding the measures of protection of rights of the indigenous, Afro-descendant, and campesino peoples, the Supreme Court of Justice has doubled down the measures for training for officers of this of the state, aiming to guarantee that the magistrates, judges, and other officers are aware and know the laws, pacts, norms, and any other norm that could be applied in these cases, and that guarantee the effective implementation of the law, preventing the needs, cultural differences, and collective condition of the rights of the Garifuna and ancestral peoples. Within the framework of implementation of the Justicia Abierta, the open justice approach, the Supreme Court of Justice for the 2023-2030 period has conducted different meetings with several stakeholders, including civil organizations, human rights defenders, campesino organizations, members of the ancestral peoples and Garifuna, to listen from their own experiences with the context of vulnerability that they face. We report that within the framework of the application of the legislative decree number 04-2022, which sets forth the law for the reconstruction of the constitutional right, and for these facts not to happen again, which sets forth in chapter number 2 the amnesty for the liberation of political prisoners and prisoners of conscience. 22 human rights defenders have been benefited from this land. On the other hand, the Office for Human Rights, by means of the Direction for Preventive Management for Human Rights and Social Conflict, has implemented different strategies to address these conflicts, and one of them has been the creation of interinstitutional working groups for the prevention and to address social conflicts from the human rights perspective in 17 departments. In the Department of Francisco Morazan, there is a space that was created by high-level authorities at national level. The objective of this working group is to provide immediate answer and follow-up to the problems related to ownership of land. Furthermore, it is through this working group that we have been able to work on the interinstitutional protocol for coordination to address conflicts over lands, territories, and environment in Honduras. All of this as part of a mandate given by President Castro to provide an integral and interinstitutional answer to all the demands and social requests of the population in all the territory, especially where there is more presence of social groups in situations of vulnerability, such as those groups that historically have fought for their right to land and other rights that derive from it. We also informed that the Unit for Reception of Cases and Immediate Response from the National Mechanism for Protection has 25 cases of indigenous councils and campesino organizations that requested actions of protection because of alerts of evictions in their communities, which allow us to coordinate actions for protection and accompaniment along with other governmental institutions that are involved. As per general information shared by the Department for the Protection of Displaced People by the violence, in the last quarter 2023, 16 families were identified that were looked after because of the displacement, and they received humanitarian assistance and emergency protection measures. Also, we provided follow-up by means of visits to this community in order to verify their situation. It is important to highlight also that we have also created a working group to harmonize the legislation, where we presented the first set of laws that had to be reformed in order to decriminalize certain norms that could criminalize champions of human rights. It counts with the participation of key stakeholders and organizations from the civil society. This effort sets forth the review of several crimes such as usurpation, alteration of terms or limits, forced displacement, and disruption of public order, which will contribute in a very positive manner to this problem regarding these legal processes by usurpation of indigenous, black, and campesino communities. With regards to the recent cases mentioned in the request for this hearing, A. Over the cases mentioned by the requesting party. Number 1, case Community Lenca Tierras del Padre Francisco Morazán. 2, the case of Consejo Indígena Lenca Río Bonito, Siguatepeque, Comayagua. 3, the case of the Council of Lenca Potrerillo La Esperanza, Comayagua. 4, the case of the Garifuna Community, Punta Gorda, Islas de la Bahía. The common element here is the practice of evictions by legal orders. The state acknowledges that the justice institutions have to act in pursuant to the law, and the members of the National Police must be duly trained in terms of the knowledge of protocols and existing manuals in order to guarantee respect to human rights of those who eventually may be evicted. To continue this presentation, I will now give the floor to Attorney Naama Lopez. Good afternoon, everyone. I am Naama Lopez. I'm the head of the Intersectorial Coordination for the Secretary for Social Development. I would like to speak about the so-called institutional gaps that were mentioned in the request. We know that one of the biggest complexities that we have in the management of governance is precisely the fact that we have to have interinstitutional coordination to intervene not only in a proactive way but also in a preventive way to prevent this from happening. Or also the right to defend rights that the defenders have. For this reason, from this Undersecretariats for Coordination and Regulation, and also from the Office of Public Policies, we have taken specific actions to strengthen the dynamic of articulation with the public institutions in order to achieve permanent spaces such as the social cabinet, from which we have been working on human rights of the ancestral lands, ancestral peoples, by means of mechanisms, plans, goals, and also we are working on taking care of different public policies that are under review, thus making sure that these institutions will have their budgets, differentiated operative plans and strategic plans that will lead these institutions to reduce the institutionalized violence that historically has affected the Black and indigenous communities of the country. In light of this, it is important to emphasize that we are avoiding to weaponize these ancestral peoples, and now our axis of work consists on conducting technical actions to guarantee human rights of the historically affected groups. In light of this, we have prioritized integral actions that have to do with the access of peoples towards social services. This as a remedy to this forced displacement that also can have an impact on said populations. Among these actions, I would like to mention the creation of the Félix Vázquez Scholarship. Its name commemorates the life and struggle of Félix Vázquez, who was killed by his labor of defense. This scholarship is given to people who wish to continue their university studies for an amount of 5,000 lempiras, which equals $205. In 2023, 437 students received this scholarship. Number 2, participation and permanent technical coordination in the construction of dialogue for the Garifuna communities between Triunfo de la Cruz and Punta Piedra to create the high-level commission for compliance of commitments and recommendations issued by the International Systems of Protection of Human Rights. This is a historical landmark because this is the first time in which there is a high-level commission in this groups that have been victims of this sort of violence. And last but not least, a new goal called compliance with the 169 agreement of the International Labour Organization, by which we provide CONAPOA the possibility to develop actions of accompaniment, systematization, and development of illustrative reports in order to guarantee the right of peoples to decide their own priorities in terms of development in the way these affects their lives, beliefs, institutions, spiritual well-being, and the lands they occupy or that they use in some way. And to finalize, we would like to read a remark that was made in the report that we have received. This analysis of information reveals systemic challenges that contribute to the lack of capacity to safeguard in an effective manner the rights to the land in Honduras. These challenges go through several institutions and they highlight key issues within the legal and administrative framework. That text deserves our attention because it has to do with an action that we have implemented from our office, which is that we have to generate a process of interinstitutional coordination in order to boost the constitutional acknowledgement of these people, because no legal framework will ever be fit to provide rights to these groups of people. Therefore, in order to achieve the necessary decolonization of the legal framework, we have suggested from CONAPOA to begin by this norm that is a starting point. In this case, the Constitution of Honduras. At the time being, the Constitution does not acknowledge these peoples, and that is one of the many actions that we are offering from the CONAPOA. Thank you for your attention. I will now give the floor to the General Inspector. Honduras acknowledges the challenges. In this case, the speed of the speaker does not allow for interpretation.
La deuda histórica, ¿terminamos?
No.
Más despacio. A la deuda histórica que tenemos con
The historical debt that we have with the people. For our intervention, we made reference to these topics, and we also acknowledge the fact that we acknowledge the state of vulnerability that these peoples are subject to, and the current government has been creating different public policies for the benefit of these communities, since we have acknowledged their needs and we are addressing them as they should. Last but not least, during this hearing we have said that we acknowledge other requests made by the different organizations, and the state commits itself to comply with them as per international norms. Thank you.
To the delegation from the state. I now give the floor to the country representative of the Office of the High Commissioner for Human Rights, Ms. Albaladejo. You have 7 minutes.
Thank you. Buenas tardes.
Good afternoon. I am Isabel Albaladejo. I'm the representative of the High Commissioner's Officer for Human Rights in Honduras. Honorable Commissioners, members of the civil society, Your Excellency, representative from the state, and also requesting an organization from the state. My participation in this hearing seeks to provide information and also to inform the Inter-American Commission without being under oath. Therefore, none of my comments must be construed as a waiver to the privileges granted by the United Nations. In our mandate, we have been conducting this follow-up on this situation, and we have been analyzing the forced displacement and the situation of human rights in the people of the communities, black and campesino groups. In 2023, the office I represent documented the execution of 38 evictions, most of them to the prejudice of campesino groups. And in those groups, we documented violence and also criminal procedures opened against those who were evicted. It worries us the issuance of eviction orders of communities that were not done in fulfillment of international regulations, because many of them were done under the figure of preemptive eviction. The use of preemptive eviction has been constant, even though international law most of them has been conducted without an exhaustive analysis of the conflict related to the land, without assessing the different circumstances that converge without securing the rights of people to be listened in an open trial by the independent court, and without taking a decision before and after the evictions. As we said in June, the agrarian community was created, and this commission was created within the framework of the National Safety Council, and from these 37 evictions, 24 have been executed after the creation of this commission. Now I will tell you about the different characteristics of the forced evictions. First of all, the need to respect the land. The unequal access to land is one of the main causes of poverty in the country, which generates also social and economic conflict that have a huge impact on human rights. They contribute to violence, and they increase the risk of displacement and violence. And they're also originated by different factors, such as the limited institutional capacity to decide the rights of property, also the overlapping of private titles of ownership over ancestral titles of ownership. To this, also, we have this, which has allowed to
aggravating inequality and bringing about a rupture in the social fabric. We should state that some national and transnational companies have violated their duty to respect human rights in the context of these projects, bringing about a negative impact on persons and the environment. Even though it's the second leading country in terms of arable lands, land distribution is extremely unequal. 15% of the owners possess 50% of the land, and only 20% of the arable lands are worked by peasant farmers. Insecurity and access to land and land tenure is another factor. This situation especially impacts indigenous and black communities who live in a critical situation because of the lack of protection of their rights to their lands and natural resources, and the acts of violence they face because they vindicate their rights in a context of impunity and lack of access to justice. As of the 1990s, with the law for the modernization and development of the agricultural sector in several parts of the country, such as Bajo Aguan, large-scale economic activities led to purchase of lands or acquisition of lands by large companies from peasant farmers, but often with coercion, and this led to eviction and dispossession of the lands. As a result, the Bajo Aguan has seen a significant rise in violence. Problems in access, recognition, and ownership of ancestral lands are aggravated by claims by third persons through administrative procedures and through the purchase of lands that are sold unlawfully. In many cases, local authorities have given full domain to third persons over indigenous lands, and they have approved farming, logging, and mining in such lands. An urgent demand of the indigenous and black lands has been clearing title to lands to resolve the difficult situation brought about by the presence of third persons on untitled lands. Clearly, the lack of technical capacity on the part of the relevant authorities, overlap of what titles do exist, lack of clearance of title, and other factors are structural causes that bring about juridical insecurity, and they impede access to land for productive use by the communities. Therefore, a cadastre of the lands of indigenous communities is needed, and it is urgently the state urgently needs to adopt measures to demarcate entitled lands as per the values, uses, traditions, and cosmovision of the indigenous peoples. Now, if we want to talk about moving on to talk about the impact of evictions on human rights, the impact on these have been carried out without a human rights approach, without a gender perspective, all of which means a direct violation of their economic, social, and environmental rights, because housing is destroyed, property is destroyed, crops are destroyed, with a negative impact on their means of subsistence, education, health, and so on. There is a serious risk of forced displacement as a result of these evictions. We've documented some evictions that take place in the midst of climatic emergencies, such as storms, leaving people in the street with no protection. Our office has not recorded, unfortunately, any case in which alternatives to evictions were explored by the authorities, or where the families that were evicted have received any sort of relocation plan, which has intensified their vulnerability. Unfortunately, in addition, looking at the relationship between the peoples and their lands and territories, well, it's an integral part of their identity and their spirituality. Many communities have had ancestral titles and have been inhabiting those lands for a long enough time to be able to claim them as ancestral territories. The use of criminal law, and I'm going to conclude, in these evictions and the negative impact on the defenders of the lands is a recurrent problem. As has been said, the reform to the criminal code based on Law 93 of 2021 has imposed illegitimate restrictions on the right to defend land. This means criminalizing peaceful conduct, pushing this conduct into the criminal sphere, which is not proper. It should be dealt with in the civil courts. This is defined as a permanent crime, facilitating evictions at any time, and it also worrisome that the judicial officers have little knowledge of the lands of indigenous Black and peasant communities that would enable them to be able to understand the claims that they put forward. The office welcomes the executive decree creating the high-level intersectoral commission to review the commitments adopted by or taken on in relation to international mechanisms and what they have had to say with respect to Garifuna communities. We hope that this leads to a better recognition of the rights of Garifuna peoples and will be the basis for the rights of indigenous peoples. We also value what the Supreme Court has said about the need to take a human rights approach to these issues. Finally, our office reiterates its offer to continue providing technical assistance to the state on this and other issues so as to move human rights forward in Honduras, always in favor of the rights of victims and persons and communities in vulnerable situations. Thank you very much.
Thank you very much, Ms. Albaldejo. Appreciate very much these very insightful comments as well as the constructive advice that you've offered. I turn now to the members of the head table, and I will first give the floor to the country rapporteur for Honduras, Commissioner to my left, Commissioner Pochak.
Muchas gracias, señor presidente.
Thank you so much. And thanks to the organizations and members of the communities that are represented. Also extend my salutation to the state of Honduras, and I also thank you for the high level of the delegation. The Commission truly thanks you for the information that you have provided and your presence in this room, and also the openness for international scrutiny and also the commitment to acknowledge this problem. We take it very positively. Also the acknowledgement of the historical debt that has to be paid, that has to be honored. I also celebrate that acknowledgement, and as we said in this hearing, that's the information that we have collected and that we collected in its last visit to Honduras. This problem, the key problem here, the origin of these evictions and these limitations and these attacks against human rights is the unequal distribution of land, insecurity in the ownership of land, historical debts that explain the situation of poverty and weakness of many of our peoples. The Inter-American Commission has taken note and took note in its last visit of the progress that the state has had in terms of regulations and also in terms of institutions. Many of those have been mentioned here in the information that you presented that we already had. Also the law for the prevention of displaced people that is not yet implemented. We're going to continue to follow up the process. That law has to be enforced as soon as possible. Also the law on I mean the progress made on the Supreme Court is something very positive. The fact that they have been involved with training, with standards, the different working groups opened by the Secretariat of Human Rights, the protocols, the National Mechanism for Protection. There are many institutions and many norms, and we have to continue working in this regard. But we have been we have heard about cases that happened a few months ago, and as the officer from the United Nations mentioned, some of those evictions took place in the last few months when these institutions and these legislations were already enforced. So we have to reinforce these mechanisms. It's not, I mean, it is important to have them, but we have to reinforce them. And I think it's concerning. I mean, the way the judicial system is being changed. I see that I am very unsatisfied with the information provided about the performance of the attorney's office and also the action that have been taken in these evictions. And something has to be done about this. The activities of training to raising awareness is not enough. The legislation has to be amended if what they use in order to breach the rights of indigenous communities is that if that legislation is valid, that law has to be changed. So all those efforts that are being, all these efforts to decriminalize, all of this has to be done as soon as possible. We have to establish also stricter protocols with regards to these evictions, because it's like they have a position in which they believe that these communities do not have any legal right to be where they are, and we have to have protocols so that these preemptive evictions do not continue to happen. I have taken note of the suggestions, the recommendations made by the different organizations for everything that can be done. We have to continue listening to organizations. We have to continue listening to the communities that are affected, and we have to provide them answers. Some of them are in very serious situation because of these evictions, because of this situation of violence that they have suffered, and we hope that the executive branch and the government will address them as it should. That's it. Thank you. Okay.
Thank you very much. I found this, again, thank you to the representatives of the civil society organizations and the state and the UN specialist for the interventions. There is this red thread in the conversation of historically marginalized historical death, also laws and mechanisms and procedures. And I wonder if we're still here and this is still happening, how effective is it? What is the impact? Because I think that that is what we want in the end, to have a positive impact and have that what is historical really be historical. So in that regard, I'm not going to go into a long I'm not going to be very long, but I have a few questions to the state. I recognize the different interventions, but I also recognize that these interventions will be really effective if they have an impact, and they can have an impact if there is participation from the indigenous and Garifuna communities and Campesino communities, and if there is transparency and if there is accountability. And in that respect, I want to know what mechanisms are there, how do they work, what is the process with respect to prior and informed consultations regarding activities in ancestral lands. What is the level of participation, or is there any participation when it comes to decision making as it regards economic activities in ancestral lands? How does that work? Is there any? And then What mechanisms are in place to prevent indigenous, Black, and Campesino communities from being evicted? What recourse is available when these evictions take place? Furthermore, we're here at the Commission, and I want to know, can the state give an update on the compliance with the precautionary measures granted by the Commission? With respect to the civil society organizations, I would like to know if they can give an update on the status of those who have been charged with and are prosecuted for usurpation, and if they have an update of the status of those who have been evicted, have they returned, how many individuals, how many family remained displaced. So basically, what data is available and how accurate and specific is that data? Thank you.
Thank you, Commissioner. And I give the floor now to our Special Rapporteur, Mr. Palomno.
Muchas gracias, Presidente.
Thank you, Chair. I'd like to thank the communities, the organizations, for having brought this topic to the Inter-American Commission on Human Rights. I would also like to thank distinguished representatives from the state for their well-documented presentation, and also the representation of the Office of the High Commissioner of the United Nations for Human Rights. I believe that the situation that has been described by the requesting parties, the requesting persons, speaks volumes about the need that is justified by a situation that, being just an isolated case, it seems to follow a certain logic of institutional practices that are more or less established in the country that explain a situation that has to be addressed from many different perspectives. I believe that the state has moved forward in terms of acknowledging the fact that there is a problem that has to be fixed, that many laws have to be amended. Also, the Constitution has to be amended. I think you mentioned that. I think that is part of that strategy, but I believe that it is very clear, the situation, in terms that we have to have a broader change in the law, because these practices have continued to happen even after these initiatives to reform the legal framework. So, for this reason, I believe it is important to ask the state about what strategies for reformation are you thinking about in order to address these issues, especially from the perspective that these evictions do not occur again, but at the same time from the perspective that these communities can recover those lands. At some point, I saw a certain degree of disconnection, or at least that's how I saw it, between the structural situation and the situation of the people who are present in this hearing. And for that reason, I would like to ask some questions specifically to the requesting party with regards to the specific situation in terms of access to goods and services, so that your economic, social and cultural and environmental rights of these groups are guaranteed as of today. Because one thing is to change the laws, the Constitution, that takes time, and something else is to provide assistance so that people may have drinking water, food, health, so that children can count on health services, pregnant women as well, so that does not depend on the time. So I mean, of the change of the laws. So I am curious about the situation of these people in these communities. And we also spoke about people who are deprived of their liberty. We spoke about the application of this crime, usurpation, within the framework of these evictions. And I would like to know a little bit more about how many people have been deprived of their liberty. I mean, how about their condition. I think that beyond the structural issues, the public policies, and the legislation, there are situations that have occurred, that have happened, that have been presented in this hearing that require an answer from these communities, or these people who were indicted. And also, I would like to request the requesting parties that all the information that you have regarding these topics, please send it to the Redesca, because that information is very relevant for our activities of follow-up. So this question about people who were deprived of their freedom, I would like to ask this question to the representative of the state, whether you have any data about people who have been charged with usurpation, specifically in this context of evictions. I don't think I have anything else to mention. I believe that the state has acknowledged everything it's doing to address this, but they have mentioned this in a very broad way. So for that reason, I would like to receive a more specific answer for these particular groups of people, and that's basically my question. Thank you. Thank you, Chair.
I see we're running out of time, but so I think most useful for me would be simply to reiterate certain standards, because we've heard a lot of some very moving testimonies from the requesting party, and some at the same time I must acknowledge from the state of Honduras some very positive commitments. But given what we've heard this afternoon, I'd just like to reinforce that the jurisprudence of our system, the inter-American system, recognizes that the protection of the relationship between indigenous and tribal peoples and their lands and resources is linked to their very existence, and thus warrants special measures of protection. We've heard this firsthand from one of the testimonies, one of the witnesses who said, we are going out of existence. And reinforcing this very standard of the inter-American system. Failure to protect and enforce these standards invariably leads to extreme poverty. We've heard about that as well, and precarity, risks to their lives, their personal integrity, and to lives with dignity. So that recognition, and not just formal recognition, but recognition and implementation of these norms is absolutely essential to the continued survival of indigenous and tribal and black and campesino peoples, and the preservation of their unique worldviews, their identity, and their culture. So we know the importance of what we're listening to this afternoon and agreeing to. I'd particularly like to welcome the acknowledgement on the part of the state of Honduras of the historical debt. All my colleagues noted that. And the current needs of these communities. I'd like to reinforce some of the very concrete recommendations that we heard from the Office of the High Commissioner for Human Rights. The need to strengthen domestic norms, the need to strengthen capacity in terms of titling, demarcation, and enforcement on the ground, the need to guarantee due process rights, to ensure independence and impartiality of the justice system, and reform of the criminal law. This has been a theme throughout the afternoon, this offense of usurpation that has been wreaking havoc on the communities. And so going forward, and with these commitments, we look forward to some movement and progress on those particular issues. I'll just end with one question, and picking up from my colleague Commissioner Demise. I'm particularly interested in given the instances that we've heard on of the eviction. And sir, if I could just refer to your comment that, you know, about the acknowledging what's happening with the evictions. But I think I heard that you say that eventually if there's an eviction, it's done properly. I'm not sure if that's just something lost in translation. But what we would hope is that there are no evictions, eventual or otherwise. But ultimately, I think, and to strengthen that process, what I'd be interested in hearing from the state is procedures around not just for consultation, but for consent. Indigenous peoples who have historically been living on these lands there should be no concessions or no movement off of the lands without their consent. You know, not just consultation. Those are my brief comments. I think, unfortunately, we are running out of time. So I'll turn the floor back now to the representatives of the requesting party. And perhaps, I think, maybe 6 minutes for your presentation. And please remember, I think Melissa is standing by. So over to you now. The floor is yours.
Muy buenas tardes. Gracias por...
Good afternoon. Thank you for giving me the floor. My name is Melissa Martinez, and I'm here in representation of the Fraternal Black Organization of Honduras, Ofra Ne. I am from Punta Gorda, the first Garifuna community in Honduras, which was founded in 1797. I'd like to tell the representatives of the state that we know about everything they've said. In November 2022, we suffered a violent eviction by police and military who were acting at orders of the Attorney General's office. 6 of us were accused of the crime of usurpation for occupying our ancestral land called Waigara. This is a proceeding in which what was shown was the institutional racism with which the Attorney General's Office and the National Police act. During our hearing, the authorities and state security made a mockery of our spiritual practices, and they deployed excessive force against the members of our Garifuna community who came to support us. Since then, we have suffered constant surveillance, threats. We have physical sequelae. One colleague was just operated on, another one had to emigrate, another lost their child. So this eviction is characterized by, well, we've been disappeared, criminalized, dispossessed of our territory by the judiciary. Once again, for this Garifuna community of Punta Gorda on 23 February of this year. I'm sorry, the government evicted us once again, or ordered an eviction once again on 23 February, but due to our legal actions, it wasn't carried out. This is just one more case, but the Garifuna people for several decades have been suffering, we have been suffering assassinations, forced disappearance, forced displacement, as a systematic practice on the part of the groups that hold economic and political power. I yield to the attorney. Very good afternoon. Responding to the state and the questions by the commission, it's important to note that while it's true that on 20 March 2023, the law on persons internally displaced was adopted, here in the hearing are the colleagues from Rio Bonito. In June of 2023, that is to say after the law was approved, they were displaced from their communities. Today it's the 16 or 17 families that the state has said are beneficiaries of that law, but they are beneficiaries in that the state has given them a housing kit without giving them land or any place to set up what the Office on Displaced Persons has given them. It's also important to say that no peasant farmer group has been a beneficiary of the amnesty law that was mentioned here, Decree 04 of 2022. The judges continue denying the peasant groups who suffered accusations of the crime of usurpation. They've refused to pardon them or lift the charges. It's also important to note that the 25 cases of the Indigenous Council, which is part of the protection mechanism, these are Indigenous councils that have been displaced, and they have suffered accusations of usurpation. They went there because they were victims of state violence. It's also important to note that the Technical Roundtable for Legislative Harmonization that the state has mentioned, we are also a party there as civil society. Well, the day that our proposal was presented in the National Congress this month of February, the state itself, through the Secretariat for Human Rights accused the workers of the crime of usurpation. So this is a criminal statute that is used to criminalize social protest in Honduras as well. So as regards these persons, their economic and social rights should be guaranteed. I must state that in the eviction processes, their schools are destroyed, as are their educational centers, and therefore no scholarships will be given to these people who have been displaced from their territories. That is what this hearing is about today. And so it's important to note that these indigenous groups who are here today, well, there are 58 persons who have been displaced, including pregnant women and children who've lost their coffee crop. In the case of Rio Bonito and Potrerillos, those are the councils that are right here in Guapinol. There were 40 people who had to leave their homes. And there are 17 persons who in Potrerillos who have been criminalized. This is an indigenous council that is here. 11 of them have been convicted, and they've been sentenced to 6 years. They're not yet in prison because of the legal actions that we have continued to pursue, but there is a firm conviction, a firm judgment against them. In the case of Ofranet, there are 15 arrest warrants and 4 proceedings still pending. And there are 30 arrest warrants in all. That is to say, arrest warrants against 30 persons of Ofranet. This for the crime of usurpation. All of these cases are for inhabiting their ancestral lands. Thank you very much.
Thank you very much. And I should have said as well that we've asked a lot of questions. Anything that you don't have time, can be submitted in writing subsequently. I give now the floor to the state, perhaps for your final concluding comments. Minutes.
Thank you very much, Chair. The Honduran state recognizes that it has a historic debt to all of the black and indigenous and rural communities of our country. And not only do we say this, but we also make a commitment to undertake the legislative reforms which, little by little, we are carrying out as a country. In that vein, Honduras is in the line of adapting its public policies to human rights so as to implement the convention. It's also been said that at this time we have a round table for humanization on harmonization for human rights. So the idea is that these populations whose rights have been violated should no longer be victims of measures that run contrary to the protection of human rights in our country. Similarly, we recognize that the measures adopted are insufficient at this time and that they must be reinforced with a view, mindful of the results obtained and the results that are the objective, looking at the situation of the communities and the international standards that Honduras is obligated to uphold. Throughout this hearing, we have noted our commitment and made known to the Commission and all the petitioners just what the measures are that the state has adopted to address the evictions in the national territory. This is a situation that also, we understand, renders the communities participating in this hearing all the more vulnerable. In that regard, I would also like to give the floor to the Minister for Security so as to also respond to some of the questions. Minister. Thank you very much, Chair. I am Gustavo Sanchez, Secretary of State for Security. As our Deputy Solicitor General says, the Honduran state recognizes its responsibility and the historic debt to our indigenous peoples. And as Secretary of State for Security, as National Police, we have become aware of this issue. That is to say, the social issue that we are talking about, and above all, the erroneous procedures that the judicial institutions of the state have used in this last decade in all these events. Some actions have been taken, such as pulling together a dispute settlement roundtable presided over by the Secretary of State for Human Rights, and the Secretary of State for Security also participates in that. We have been working from the Secretary of State and from the National Police to deconstruct the mindset that has existed and that has been inculcated in the members of the National Police when disproportionate use of force has been made in events of this sort. And so, pulling together the national and international rules, we've got a manual on the use of force. And this summarizes the key points in the national law and international law in order to make sure that police action complies with human rights and respects human rights. In addition, we have prepared a protocol for action of the National Police in the case of action of the police in public spaces. As National Police, there is a legal system that we are to apply, but we've been working on this. We're working to train. Well, we've had more than 40 events for training, 40,000 events for training police officials. And in these years, not a single tear gas canister has been directed against persons in Honduras, particularly not against indigenous persons. Just to round out in terms of the Roundtable for Legislative Modernization, the minister already noted this. There are some limiting factors, but nonetheless, this is a working initiative to review all of these provisions and to be able to carry out some of the standards that the Commissioner mentioned. This first, and this, in terms of the question by the Rapporteur on Public Policy and Secretary for Social Development, we are working on public policy for indigenous and Afro-Hondurans. There was a policy that did not uphold the standards, rather continued to foster the systemic racism that has been denounced here. So we have been working on this. I could also mention we've been working to mainstream the approach to indigenous peoples in the new law on Social Security. As you may know, we had a reform to derogate and declare unconstitutional the previous legal framework because there was no space for social protection, and we know that the indigenous and Afro-Honduran communities are not so within this scheme of protection. Finally, and not least important, we'd like to note that this high-level commission, and that's why I said this is an important milestone, because now the community of Punta Piedra, Triunfo de la Cruz, and also San Juan, they are also part of these commissions with voice and vote. And this is important, and it also goes to a recommendation which I'd like to mention to the requesting party, which is we, as the state, face the challenge of creating a space where these organizations can be on an ongoing, permanent basis. We think that this hearing, it's good that this hearing is being held, but as public institutional framework, we need to have standing for dialogues that would meet on a more regular basis. We'd also like to receive feedback from the organizations about what we should change or improve before coming to a hearing, and this will help us a great deal to be able to work jointly with these organizations, and that is all I have to say.
I apologize for having had to shorten your time, but we are actually completely out of time. But that said, I'd like to think it's been a very useful afternoon, a very useful hearing, and I'd like to begin by thanking all the representatives of the requesting party for your testimony and for bringing this to us. I'd like to acknowledge all of the representatives who are in Honduras and sitting there paying such close attention, and also to Melissa, who has patiently waited her turn. Thank you very much, and we appreciated very much hearing from you. Also to the state, there were some very important commitments that you've made. I'd simply like to acknowledge them and to say, your promises of legislative reforms, of measures, acknowledging that there were erroneous procedures, but that those will be changed. And of course, as you said, to create spaces for dialogue. All of these are very useful reforms, and I think it gives us hope that we can look forward to a Honduras where there's no evictions in the future and no forced displacements. I know that this wouldn't happen overnight, but I'd like to reiterate the position of the Commission that we are here to continue monitoring and to continue to receive information and to facilitate dialogue with the state in the future to make these goals a reality. So thank you very much to both the state and to the requesting party, and I wish you a very good evening, all of you. Thank you.
I am a member of the Inter-American Commission on Human Rights, and I would now like to call to order this hearing number 12 of this 189th regular period of sessions. On this occasion, I'd like to recall, before beginning the hearing, that the Inter-American Commission on Human Rights is celebrating its 65th anniversary this year, 65 years of work committed to promotion and defense of human rights, thanks to the interest on the part of the states and civil society to give life to the American Convention on Human Rights and the Inter-American Democratic Charter. Since 1959, hundreds of professionals have gone through this institution, and thousands of individuals and organizations have come before the Commission seeking justice and reparation. We mark these 65 years, which have had more than 100 on-site visits and the respective reports, more than 1,000 precautionary measures, more than 750 reports on the merits, 220 friendly settlements, and 200-plus cases forwarded to the Inter-American Court of Human Rights. The victims are, as is well known, at the center of the work of the Commission and the priority. Also, before introducing the topic and telling you how we'll distribute the time, I would note that this hearing seeks to be inclusive, and so we ask all of those who are going to participate to please, before you make your remarks, to state your name, your position, the name of the institution you represent, and then, after you speak, please, when you take the floor once again, please state your name so that any persons who are visually impaired can know who is speaking. And I also state this as rapporteur for persons with disabilities, and recall that we have subtitles on Zoom in this hearing, and that anyone can activate that directly, and you can choose the size of the font. And also, this hearing is available through the institutional channels of the Inter-American Commission. This is one of the most important hearings in this period of sessions. The topic is the situation of judicial independence. We have a large number of persons in attendance. There are 33, well, there are many organizations that requested this hearing, and I will at first give these organizations 33 minutes. Then I'd like to thank the Special Rapporteur on Judicial Independence of the UN.
And I will give you 5 minutes for your intervention.
And after that, the Commission will have 22 minutes, and at the end, I will give another half hour, approximately 2 minutes per organization, to the organizations who requested the hearing. So without more, I offer the floor, and I will be very strict with the time. We have no other option. We need to stick to the times. And with that, I give the floor to the organizations that sought this hearing, whoever is going to speak first. Thank you very much. Esteemed members of the Commission, Special Rapporteurs of the Inter-American Commission and the United Nations, my name is Ursula Indacochea. I'm the Director of the Judicial Independence Program of the Due Process of Law Foundation. Cordial greetings, and I'm grateful for the initiative. Selection processes are a central event for the independence of justice systems. Adequate designation of the high-level judicial and prosecutorial authorities have a direct and visible impact on the fundamental elements of democracy, such as separation of power, guarantees of human rights, and alternation of powers. A regional organization with more than 20 years' experience on these issues, we identify 4 main problems. The first is the growing influence of politics on designations. This influence is channeled in several ways, sometimes through the participation of political organs in the selection mechanisms. Legislatures or presidents entrusted with evaluating, nominating, or designating, but also by electing persons who have political party links or indirectly by reforms to increase or reduce the size of the courts, the terms of the judges, early retirement, or by having election by direct popular vote as a selection mechanism. This exponentially increases the risk of political manipulation of justice for anti-democratic ends. It's all the more serious when the political system has been penetrated by organized crime. Unfortunately, inter-American standards consider the political mechanisms as one more and only recommend reinforced safeguards. The report of the Inter-American Commission on Corruption and Human Rights took another step forward on advising directly against these mechanisms, but we need more clear-cut standards on this issue to keep politics far away from justice. The second problem is the increase of interim high-level authorities as the result of a failure to activate selection mechanisms. Guatemala took 4 years to appoint members of its courts. Peru accumulated mandates of members of expired mandates of its members of the Constitutional Court to negotiate them and distribute them politically. Colombia has taken time to, and has taken at times months to select a attorney general, and Bolivia is behind in judicial elections. Third, there's a lack of spaces for citizen participation in selection process. Even though there's a right to participate in public matters, judicial organizations continue to be a forbidden space for exercising this. The countries often think that selection processes don't think that selection processes should comply with rules of maximum transparency or access to public information, which are required for other areas of state activity in order to regulate mechanisms of participation or effective remedies for citizens to be able to denounce irregularities and remedy them. This seriously limits social scrutiny and further remove citizens from justice. I'll refer to the fourth problem on gender parity, and I'll make some direct petitions to the Commission when I speak for the second time. Thank you. Thank you. My name is Claudia Escobar Mejia. I'm a Guatemalan lawyer, and I'm director of the organization Be Just. I served as a judge on the Court of Appeals in Guatemala until, because of defending judicial independence, I was obligated to leave the country, or forced to leave the country because of threats. This year, Guatemala is facing a crucial moment with the election of the members of the Supreme Court and the appellate courts at the national level. Today, I wish to state before this distinguished commission a serious obstacle to judicial independence in Guatemala, which is the system for selecting judges. While access to the judiciary for justice of peace or community level or first instance judges is based on meritocratic competitive process guaranteeing judicial independence, the process for electing judges at the appellate level and at the level of the Supreme Court is plagued by flaws and permeable to manipulation. Those judges are selected through nomination committees, a mechanism that is susceptible to cooptation by private interests and corrupt figures, favoring political discretion over technical merit. The nomination committees made up of representatives of academia through the law schools, the Bar Association, and judges. These have been criticized because they're vulnerable to bribes, political negotiations, and in extreme cases, the establishment of law schools for the sole purpose of influencing these processes. These practices have been denounced repeatedly by civil society and are subject to investigations by the Attorney General's Office in 2014 and 2019. In addition, these commissions establish selection criteria which, far from promoting equal conditions, favor certain candidates, undermining the right to participate in public positions in equal conditions. To this is added the insufficient role of the Judicial Council. Its independence on the Supreme Court undermines its or independence of the Supreme Court undermines its political independence. In Guatemala, there's been a lack of support for judges, which has forced many to go into exile. The lack of an effective judicial career, the politicization of elections to the high-level courts, the institutional cooptation, and the lack of protection for judges and the weak mechanisms are discouraging for defending judicial independence in the country. In view of all the foregoing, I affirm that those who struggle for an independent judiciary in Guatemala face adverse conditions. With this testimony, I seek not only to give visibility to those challenges, but also to urge the Inter-American Commission on Human Rights to consider measures that support the strengthening of judicial independence in Guatemala, especially this year, in which judges of the Supreme Court and the Courts of Appeals will be elected. Thank you for your attention. I now yield to my colleague. Good afternoon, everyone. My name is Claudia Paz. I'm the director of CIDH for Mexico and Central America. I thank you, Honorable Commission, for convening this very important hearing. I'm going to supplement what has been said about Guatemala. Guatemala is experiencing some hope with the change in government. Nonetheless, democratic progress depends largely on freeing the highest spheres of the judiciary from corruption. Likewise, the Attorney General's office, these have been improperly co-opted. This co-optation has guaranteed impunity in cases, in large corruption cases and cases involving major human rights violations. And it's allowed the criminalization of dissident voices led by the Attorney General's office. As a result, more than 70 of us are in exile because there is no judicial independence in the country. As was already indicated, the latest selection processes of the courts were plagued by irregularities. As a result, a group of judicial officers have presented before this Honorable Commission a petition. This case represents an opportunity to recognize the violations committed by the state and to see progress in structural measures that guarantee a selection process based on merit and suitability. As a result, we urge that the report on the merits be issued soon. We reiterate the key importance of the process of selecting members of the high-level courts, given the complete change in the composition of the Supreme Court and the Courts of Appeals. That's a total of 148 positions. We welcome the intent of the Commission to make a visit to the country, to Guatemala. We hope that the selection process will be a key issue that will deter possible arbitrariness and influence peddling in this process. We urge the Honorable Commission to monitor the selection process, to offer technical assistance, and to make recommendations to the state. This monitoring should include the election of commissioners by the Bar Association and the Judicial Institute. This will happen in June, and the work of the nomination committees will happen in August. I devote one last minute to raise a warning about El Salvador. In March, the process will begin for electing 1/3 of the members of the Supreme Court, 5 of 15. This will be done by the Legislative Assembly, which is under the absolute control of the executive. In 2021, the previous legislature illegally removed the five members of the Constitutional Chamber and put 5 persons supportive of the government in those positions. In June 2021, 5 more Supreme Court judges were elected. So with this election, it is anticipated that there will be absolute political control over the Supreme Court. With this, I yield to my colleague. Good afternoon. Ali Dañez, co-director of Acceso a la Justicia Venezuela. In Venezuela, the lack of selection processes for judges in keeping with international standards and domestic rules continues, and there is an absolute lack of public policies to guarantee gender equity in this area. With respect to this last point, there is a law on equal opportunities for women that dates to 1999, but the substantive rules thereof are older insofar as that law is only an amendment of the original 1993 laws. So it is a fact that the rules on gender equity in the country have not been updated in 3 decades. That law indicates in Article 21 the obligation for autonomous institutes and state enterprises only that there be just one woman on their boards of directors without making any mention of the presence of women elsewhere and without there being any such obligation in respect of the body organs of the other public powers. In the case of state institutions, it is required that there be support for the participation of women in professional positions, and 30 years later, this has not been accompanied by policies and rules to support not only equal opportunity but effective inclusion of women in all of the different branches of government. And so there is no particular law that guarantees gender equity in the judiciary. Finally, we should note that even though the amendment to the organic law on the right of women to a life free from violence was included to address violence against women or any other forms of coercion that would limit women's access to elective positions. as there are no rules that govern equity for women in public positions, there are no parameters for enforcing this law. Without specific rules that require gender equity, one cannot issue sanctions against conduct that is against that. Public competitive processes are the only way to get into the judiciary, according to the Constitution. Yet they've not been have not occurred since 2003. They've instead there has been discretional appointments. 1,415 judges were appointed in 2002-2003, and considering that there are some 1,200 courts, that means that in just 2 years, half of the country's judges have been appointed by discretion, without guaranteeing the most basic rules of the judicial career service. The state seek to have judges already appointed by discretion go through competitive processes, but this is discriminatory because they don't meet the constitutional requirement that they be public and open competitions for all those who meet the requirements. Finally, the requirement for electing judges to the Supreme Court have not been abided by. The Constitution notes they cannot be reelected, and the appointments made in 2022, 60% were reelected, which means that those judges will serve for more than for 12 years, more than the Constitution allows, and this has already been seen in some cases, and this is just one among many serious irregularities that are committed in the election of judges. Thank you very much. Good afternoon. My name is Sofia Bautista. I'm a member of the Colombian Commission of Jurists. In Colombia, despite the advances by the government in the participation of women in the public sector in decision-making positions in the judiciary, there's still an important gap in terms of gender parity. As a result, I'll refer to the participation of women in the high courts and then to the current challenges in election and appointment processes. First, the Corporación Excelencia para la Justicia identified that since 1991, the participation of women has advanced very little in the high courts. In 2021, women accounted for 15% of the positions of the Supreme Court, 24% in the Council of State, and 20% in the Superior Judicial Council. Compared to the ECLAC data, Colombia continues to be below average for Latin America and the Caribbean. In 2023, even though there's more women in the judiciary of the 93 members of the high-level courts, only 27 are women, less than one-third. In addition, only one woman has been elected Attorney General. It should be noted that the high-level courts are not included in the report on the quota law, which is a mechanism that establishes a minimum threshold of 30% participation. Only the Office of the Attorney General and the Superior Judicial Council have reported, and in those, only 36% of the decision-making positions are occupied by women. Second, there are challenges when it comes to electing the new Attorney General of the nation. To elect this position as of August 2023, the President of the Republic presented a slate made up of 3 women, all of whom have extensive experience. But the one who chooses of the 3, the Supreme Court, has put off the decision many times. In previous periods, the average time has been 9 to 82 days, but today it's been 154 days with no election of the Attorney General. The aggravating factor is that there are major questions having to do with the suitability of the person who has remained in charge of the Attorney General's office. To this is the tutela action that was brought by a member of the Supreme Court of Justice with no basis, where he called into question the slate because it's made up of only women without including a single man among the 3. We are grateful that the Inter-American Commission has called on the Supreme Court to elect the new Attorney General, mindful that the absence of an Attorney General and having interim people could have a negative impact on the fight against impunity. It could have a negative impact on judicial independence as well. Finally, the participation of women in the high-level courts and in the election of the new Attorney General would be a clear sign, first, of the commitment of the justice system to victims so as to go forward in fighting impunity, and second, recognition of the role that is played by women in justice. Thank you so much, and I now yield. Thank you very much. My name is Adriano Ruc. I'm a Costa Rican judge, and I'm the president of the Costa Rican Association of the Judiciary and of the Latin American Federation of Judges, which pulls together or includes 19 Latin American countries. We note with great concern that most of the judiciaries in the region are being seriously attacked in terms of judicial independence. Some of these aimed specifically at weakening guarantees of judicial independence. We find ourselves in scenarios in which Judges of high-level courts have been removed on an irregular manner or operating conditions that require that they step down because of negative impact on their rights, or as in the case of Guatemala, Peru, and Bolivia, among others, they remain in their positions beyond the constitutional terms. In the case of Costa Rica, it's not been possible to bring about a change for the processes to incorporate international standards. To achieve this objective, legislative measures have been adopted that tend to diminish permanence in the position, facilitating the removal of judges when the judiciary is considered an obstacle to the government agendas in the case of El Salvador, Guatemala, Bolivia, Colombia, and really all of Latin America. Delegitimizing the judicial function, the executive doing so, or the legislature doing so, or other organized groups doing so. This happens in order to more easily facilitate the adoption of laws that weaken the judiciaries. But as president of the Federation, I cannot but refer in a forum as important as this to an issue that is great importance and requires urgent attention, which is security for judicial officers. The insecurity of judicial officers is seriously compromising judicial independence because the failure of the state to adopt efficient experiences. This has resulted in the assassination and permanent threats to judges, prosecutors, and their family members. Organized crime is gaining ground or has co-opted the state, as in Ecuador, Mexico, Bolivia, Guatemala, and recently, unfortunately, Costa Rica, where yesterday a former judge was assassinated, and today a defense attorney. The day before yesterday, a witness who was protected was assassinated in the province of Limon, right in front of the court. In a case where he was to testify in Costa Rica. There are also budgetary limitations that limit access to the public funds necessary for the judiciary to be able to fight organized crime. This is a limitation that answers to two laws, and this reflects the situation I just described, that limit the limited budget, also affects judicial stability, and as a result, in 2 years, 804 persons have resigned from the judiciary. Judges, prosecutors, defense attorneys, medical forensic physicians, and police. This is a general situation of weakening of the judiciary region-wide with serious negative consequences on the quality of service of the justice service provided to the citizenry. I yield to my colleague. Distinguished commissioners, my name is Maria Dolores Mino. I am Director Executive of the Observatory of Justice and Rights of Ecuador. While the problem of the politicization and use of justice in Ecuador is not new, in the last year, the judicial function has faced an institutional crisis that involves its highest level authorities and which evidences growing infiltration of organized crime at all levels of the Ecuador administration of justice. This is now the main threat to judicial independence and impartiality in recent months, and based on the initiation of the mega case known as metastasis, one sees the ties between corrupt officials and others. This case has involved 20 judicial officers, including provincial judges, prosecutors, and other attorneys. The main person involved there was the head of the Judicial Council, which is the disciplinary body over the judiciary, who stepped down after being called to trial. The metastasis case evidences that the connections between organized crime groups, political, corrupt politicians, and others co-opted by organized crime have resulted in judicial cases of great public interest going nowhere, favoring impunity in corruption and drug trafficking. There are also cases that involve former members of the judiciary of corruption. And also, judges have released members of organized crime. In this context, there are a growing number of terrorist attacks and threats to the life and integrity of judicial officers. In 2023, there were 24 instances of attacks, including 2 against, prosecutors who were assassinated. There were also 3 bombs that went off against judicial places. and to direct threats against judges, among others. And so far in 2024, also in the context of the state of emergency that was declared on 9 January 2024, there have been attacks with bombs at the home of the President of the Supreme Court of Justice, death threats to the Attorney General, and the assassination of Cesar Suarez, a prosecutor who is investigating drug trafficking cases and the takeover by criminal groups of a television studio on 9 January of this year. In that context, we call on the Honorable Inter-American Commission to call on Ecuador to urgently adopt a comprehensive protection program for the judicial officers and to investigate diligently and in timely fashion the attacks against them, and to urge the state to give impetus to a constitutional and statutory reform that is comprehensive and that protects judicial officers from organized crime and that prevents impunity. I now yield to the next speaker. Good afternoon. I'm Marisol Mendez, and I represent the Foundation for Justice and the collective justice that we want in Mexico. And for several years, we have been experiencing attacks on judicial independence by the executive and legislative branches, which include smearing of judges and members of the Supreme Court when they issue judgments that are unfavorable to certain policies. It also includes requests for investigations, requests for impeachments, and budget cutbacks, among others. These attacks are a risk of undermining the judiciary as a counterweight, a check and balance on the political departments of government, and therefore it's a threat to democracy. The most recent attack is framed within an initiative to reform the entire judiciary, which includes, first, a massive changeover in judges, and second, a change in the selection process to a popular vote system, which risks further politicizing appointments without taking into account criteria of suitability and professionalization of the judicial service. Third, the creation of a new disciplinary court that could subjugate judicial independence. And fourth, the establishment of limitations on amparo proceedings. Certainly, the judiciary has challenges, such as having transparency and accountability mechanisms, creating strategies for getting closer to the citizens, democratizing amparo proceedings to make them accessible to all, establishing mechanisms of supervision that are objective or that are merit-based. The reform initiative that I mentioned is incomplete. It does not include the Office of Prosecutors that are responsible for 98% of the impunity in the country, even though the prosecutorial officers are fundamental for accessing justice, because their work is crucial in trials going forward and the judgments being enforced. The current political moment calls on citizens to focus on elections. It's not the best time to also discuss a judicial reform that requires time and needs to be put together in a constructive manner with academia and expert civil society. In Mexico and in the region, we lack standards for selection in the high courts. That's why it's essential that the Inter-American Commission head up the creation of such entities. We also highlight the need to have adequate and effective resources to be able to fight irregularities in these processes by the citizens. We can mention the case of one judge who should have been appointed by the Congress of Oaxaca, which failed to meet in the time established by law, which led the governor to freely designate whoever he wanted without any requirement of suitability. This case is currently before the Inter-American Commission. It is necessary to have regional standards for the selection processes in the high-level courts and to generate indicators to gauge the impact on democracy due to the attacks on judicial independence in the countries. Thank you, and I yield.
Ilustres comisionadas y comisionados, mi nombre es Cruz Silva, integrante del Instituto de Defensa Legal de Perú.
The legal system has been affected after almost 24 years of the fall of the dictatorship of Fujimori, precisely because of mafias related to the organized crime. These mafias have reached spaces such as the Congress of the Republic, where they use the mechanism of control against justice officers, and also they create spaces of disinformation material that is used by the Congress in order to attack these people. The main ways to remove the officers who do their jobs is basically complaints against the National Board for Justice and Elections, draft laws, also the weaponization of criminal complaints that criminalize attorneys, even journalists such as Gustavo Gorriti, and also journalists from civil organizations. Also, the lack of amparos that request their rights to be protected. Also, the violation by means of the Supreme Court when they freed dictator Fujimori and when they imposed other people. Also, the construction of the image of the national enemy against officers of the justice system, and also their pact with certain authorities of the justice system in order to remove certain attorneys. Political parties such as Renovación Popular, Alianza para el Progreso, el APRA, their members, even some of them at large, many of them have processes before the justice. The objective is to get rid of officers and also just to receive the benefits from the state. Last Monday, the Permanent Commission of the Congress approved to replace all the members of the National Board for Justice that assesses the resumes of people who aspire to be the members of the Supreme Court of Justice. So this means that the former attorney of the country is going to be back at her position, and she's a person that has been under investigation. Dear Commissioners, our democracy is not a democracy any longer because of the political and criminal mafias, the Congress, and the coexistence with their with the executive branch. Thank you.
Muchas gracias. Mi nombre.
Thank you so much. I am Robert Darío Cuella, Executive Director of the Observatorio de Justicia from Bolivia. I send our regards to all the commissioners and executive secretary, and also the UN rapporteur, and also the officers from the Inter-American Court of Human Rights. The crisis that Bolivia has been suffering in terms of justice has had a big effect on the rule of law and also the validity of human rights in Bolivia, which has been deepened since 2009 because of the way in which the members of the higher court are appointed by popular vote. Now we also have the decision made by the magistrates of the Supreme Court of Justice with the explicit approval of the executive branch, where they self-extend their positions, which by express mandate of the Constitution expired on December 31, 2023. In order to consummate this breach of the democratic system in the terms set forth into the Inter-American Charter, the Constitutional Chamber issued two resolutions which are contrary to the Constitution. First, by means of a Constitutional Declaration 049-2023, it decided to extend indefinitely the mandates of the highest legal authorities of the country, even if the Constitution itself orders that said officers have to be elected for just for one time for a 6-year period, and they cannot be re-elected. So this breaches the principle of independence. Then, by means of an act that can only be referred to as a serious rupture of the democratic thread, this court issued a precautionary measure that orders lawmakers from the Congress of the Republic to follow and to abide by their self-extension before they even call for any other election, before they even discuss any law. So, in an open challenge against the democratic system of government, prevents the legislative branch to conduct its legislative work, thus breaking the principle of separation of powers. In this regard, we request this Honorable Commission that in fulfillment of the Inter-American Convention on Human Rights, it must develop standards on this matter, and it has to pronounce itself regarding these serious acts hereby denounced, warning the state of Bolivia that all these acts should be null and void. in Bolivia, there is no such a law that will allow for these magistrates to extend their own period of time. No member of the higher court or any other tribunal can issue resolutions in their own, because in their own with their own interest, because of the evident conflict of interest. Thank you so much, and I yield the rest of my time. I am Marcelo Octavio de Jesus. I represent an NGO from Argentina called FORES, created 48 years ago to improve the justice, judicial independence, and transparency. There are two topics related to the independence in terms of justice in Argentina: the impunity of corruption, and the second, that said corruption is so spread that it has led to levels of poverty that were unseen in Venezuela. Poverty and corruption are the same faces of one coin. Argentina approved the Inter-American Charter, which, as per its Article number 7, is indispensable for human rights. The Inter-American Court established that in 2021 the relation between corruption and human rights. But FORES wanted to deepen this relation. The product of corruption in Argentina is poverty, and corruption seeks impunity. Let's take a look at the seriousness of this situation. 50% of the population in Argentina is poor as of now. As per the last report of the IMF, FORES proved that this has led to less inclusion. On the other hand, Argentina is 98 out of 180 countries in terms of corruption, and we have, and this situation is worsening. Now, the problem for Argentina doesn't have to do with the laws. FORES proved that Argentina has enough anti-corruption treaties and laws. Also, the main problem is not the justice that already sentenced one president, former vice president, and other officers, but just 6% of the cases related to corruption receive a sentence, or the other do not make it that fast. The time has expired. I will give you one more minute. The assassination of one attorney in 2017 that was going to present his case is an example of this. Also, the reform of the laws for political benefit. Also, the reform of the institution that appointed judges. It had 20 cases, and it didn't rule on any of them. And in 2013, they decided to appoint them based on politics. So the image of justice is part of independence. But when a president says that the investigation for corruption is something that should not be prone to the justice, for promoting this simply offers benefits to corrupt officers. And number 5, judges, temporary judges and attorneys are appointed. Number 6, thank you. Well, I started afterwards because some people took my out. Can I have 10 more seconds? So, ideologization of justice with the narrative of lawfare. Lawfare sees justice as an army at war for which you have to appoint judges that are soldiers. Thank you. Thank you so much. Thank you so much.
Thank you so much for coming to Washington, D.C. for this hearing. So the floor is yours for 5 minutes. Thank you.
Thank you very much. My name is Margaret Satterthwaite, and I'm the UN Special Rapporteur on the independence of judges and lawyers. And I would like to start by thanking you, commissioners, for the invitation to be here. It's a real honor to be here with you today, and especially to Commissioner Caballero. I look forward to working with you closely on the issues that are being brought before us today. So very briefly, I'd like to speak about a few specific challenges that I consider the most important and urgent to think about when we're talking about the status of judicial independence in the American continent. In the 15 months since I took up the mandate, I've sent 30 communications to governments in the American continent concerning human rights violations related to the judicial system. And these very much span from the most severe human rights violations to more, we might say, daily violations of judicial independence. I'm concerned very much about the instrumentalization of the judiciary and the legal framework in attacks against justice operators. I'm concerned at reports that suggest the justice system in some countries in the region, and even the legal framework itself, rather than being used to seek justice and ensure the enjoyment and protection of human rights, is being used by powerful actors to threaten, silence, and discourage efforts to hold authorities accountable. This is achieved by imposing financial burdens on independent judges and brave prosecutors, and even more worryingly, through unfounded criminal accusations and extended pretrial detention of judges, prosecutors, and human rights lawyers. When criminal law is instrumentalized to attack independent judges and prosecutors, we also see accusations made both online and in the press, often by elected officials. These actions appear to be aimed at overwhelming and silencing justice operators beyond those directly targeted. On this subject, I've expressed my grave concern about the repeated targeting of judges, prosecutors, and lawyers in Guatemala, where the mandate has expressed repeated and grave concern over the criminalization and detention of judges, former anti-corruption prosecutors, and human rights lawyers. I have also forcefully condemned actions targeting lawyers in Nicaragua, where resolutions from the Supreme Court suspended 26 attorneys from the bar after they were declared traitors of the homeland, following a judicial decision to forcibly exile 222 individuals, including some of these very lawyers. Let me turn briefly to situations where there have been delays due to lack of agreement within the legislature to carry out the appointment of judges to high courts within the deadlines required by law. I'm also very concerned about cases where civil society has brought forward legitimate evidence questioning whether the appropriate profiles have been appointed to high court positions. I take this opportunity to highlight the importance of holding transparent, participatory, and comprehensive processes to appoint candidates of the highest merit to the judicial posts. Discussion of such candidates must focus on the assessment of training, real-life capacity, and temperament of the candidates, and such appointments should not be the subject of political deal-making. On judicial appointments, I'm closely following events in Bolivia, Ecuador, El Salvador, Guatemala, and Mexico. On Attorney General appointments, I'm following the situation in El Salvador and Colombia. I am pleased that this Commission and civil society are also following all of these processes very carefully, and I hope the international community will do the same. I'm dismayed at the great vulnerability of justice operators who deal with organized crime and corruption cases in the Latin American region. I've expressed my concern that numerous prosecutors have been assassinated and several judicial officials have been subjected to intimidation and threats in Ecuador. Several judicial buildings have received bomb threats, as you've already heard just a few minutes ago. Reports suggest that conditions have declined dramatically in the past few months. In addition, I've expressed concern that numerous judges in the region have suffered direct attacks. Justice Wilner Morin, who was investigating a number of corruption cases in Haiti, survived an assassination attempt in May 2023. In recent months, of course, the security situation has worsened appreciably in Haiti, and the situation of judges and prosecutors is precarious. These attacks and threats undermine the principle of independence of the judicial system, directly impacting the work of judges and prosecutors in their fight against corruption and organized crime. In addition to violating their fundamental rights and freedoms, this also threatens the rights of people who would like to come before them. I'm also concerned at the public statements from high-level public officials against the work of independent judges, brave prosecutors, and lawyers just doing their job. I'd like to recall that international standards on freedom of expression provide that the exercise of this right carries with it special duties and responsibilities for public officials. On structural independence of the judiciaries in the region, I regret to note that some countries assign insufficient resources to the judicial system, despite clear requests from the judiciary themselves for additional resources. The judiciary...
Margaret, I'm so sorry.
Okay.
Time is up. If you can just wrap up in 30 seconds, that would be great.
Absolutely. So in addition to financing, we have seen manipulation of the issue of financing of the judiciary on repeated occasions. Excellencies, colleagues, I commend the important leadership of this commission on the issues covered by my mandate. The jurisprudence of the commission is an essential touchstone for the development of universal norms. Your promotional work is essential. I most warmly welcome the opportunity to be here today, and I look forward to closer relationship between my mandate and that of Commissioner Caballero. Thank you.
Thank you so much. Ahora vamos a abrir un...
So now we're going to open a round of questions for 20 minutes. Before, I would like to clarify something for our attendance and for the audience that's following us through the social media of the Inter-American Commission on Human Rights, which is that the Commission also has its own rules in terms of independence, and for that reason, I would beg you to please excuse us, because Commissioner Caballero is going to, cannot refer to topics related to Mexico, and Officer Pocha cannot discuss topics related to Argentina, and I cannot make any reference whatsoever to matters related to Colombia. In that regard, I would like to give the floor first to Commissioner Caballero, who is, besides being the rapporteur for several countries, is also the rapporteur for the independence, judicial independence of the Inter-American Commission. Mr. Caballero, please, you have the floor. Good afternoon. Thank you so much. I would like to thank you, and I recognize all the concerns of the civil society, and thank you. Thank you for coming to this hearing. I also thank the message from the rapporteur of the United Nations, Margaret. And I will try to be brief, because this is actually an open reflection that I would like to share. And then if there's something else, of course, we'll cover. But it has to do with what we have heard. I think that the inter-American system has given a very strong tone to this topic of judicial independence. There is a 2013 report, but the topic of the appointing of officers for the higher court, it's particularly relevant in terms of the democracy and in terms of the balances and in the democracy. So in this regard, I have three reflections that I would like to share with you that make me think whether we would have to, somebody even mentioned this, maybe because we have very recent cases of the Inter-American Commission, Cajabuca Vázquez, Amija Cagallón versus Ecuador, and many other. And so the first point would be whether in this appointment of officers for the higher courts, we have to define the three scenarios: in direct or indirect election, a strong presence of the executive branch with the higher chamber, normally the Senate, or we understand that we can have a more plural participation from the civil society, the academia, social justice officers, attorneys, lawyers. That's the first point. The second point is that I wish we could deepen on this reflection, whether we have thought about reforms in the democratic tradition, that the higher courts, they have to be bulletproof. They have to have higher salaries, strong system of responsibility, such as the conditions for political trials. So I wonder whether this is relevant or not, or self-extensions in the case of vacancies. And this is a very relevant topic. And the third topic is, and it was mentioned here, whether we are in a time in which we have to create affirmative actions in order to enforce a gender equality or coexistence of underrepresented groups. So these are the 3 points that I think we could perhaps we could discuss. And thank you. Thank you for your presence. Thank you so much. Thank you, Commissioner Caballero, Commissioner Andrea. Thank you. I will be brief, so the civil society will have more time for their reflections. Thank you for your presence and thank you for your contributions. Yes, the Commission is in this process of reflection about the need to update this report from 2013 and these remarks from Commissioner Caballero about relating judicial independence and its close relation to democratic institutions. We are seeing in many countries of our region crisis, institutional crisis in our legal system. We're not speaking about one attorney, one magistrate, one specific situation. There is a strong crisis, and this crisis in terms of judicial independence is also a crisis of the inter-American system, because in the way that these systems do not offer solutions, in the way these judicial systems are not legitimate, in the way they do not comply with their obligation of working for human rights, we cannot do this from the inter-American system. So we have to handle this crisis, and one of the topics is that there is a crisis in this system of checks and balances. We are used, since from the inter-American system, we reflect about the attacks from the political field, but we have to continue working on this from the perspective of the instrumentalization of this power, but also the system of power of checks, and I mean, we need it. We have to have policies. It resists policies change, so we have to think about it from the standards about how this crisis and I believe that what we are missing is the debate about judicial reform and human rights. The agenda of human rights has to permeate in these processes, because a big part of the crisis that we have been discussing have to do with the fact that those legal reforms that were brought forward in many of our countries were not done with the perspective of human rights. We continue to see attorneys that guarantee massive impunity, systematic impunity in our country, and this is not part of the debate about legal reform. So we have to make sure that human rights are discussed. So I will leave it at that in order to have more time to hear your contribution. Now I would like to give the floor to Jorge Mesa. Thank you so much, Commissioner Bernal. I would like to deepen and to elaborate in some comments I have heard about the standards. I would like to know your opinion. The Commission has followed the jurisprudence of the Inter-American Court when it comes to guarantees of judicial independence, also what refers to the separation of this position. In your 2013 position, the Commission already expressed itself about these systems that will ensure the suitability of those who are to be elected based on their merits. It was said here that the Commission had established a series of safeguards or guarantees, which, as per the report, among those guarantees, the periods, guarantees for equal access, participation of the civil society, qualification based on merits, objectives, and even following what was mentioned by the rapporteur of the United Nations that participated here, Mrs. Gabriela. She participated in this process, and what was said by the United Nations, the Commission recommended to establish an independent body that would be responsible for the government administration. So beyond this, as we said here about the development of the standards, I wanted to ask you whether you consider that certain designs that exist in terms of participation would not be conventional. Would that be, is that the direction in which we have to go? Because there are already standards in place. And last, there are some important examples that we could follow in Europe. So I wanted to ask the rapporteur and the civil society your opinion about this. I mean, some cases that in Iceland and in Poland in the European Union about the selection, the mechanism for selection. Thank you, and thank you, Chair. Thank you. Now I would like to give the floor to the Executive Secretariat, Tatiana. Thank you, Chair. First Vice President. Well, first of all, I would like to thank you for your presence here today. This hearing was carefully crafted by Commissioner Caballero because we have been listening in the region from the follow-up. We have been listening to different expressions, just similar to what you have mentioned. We have here 8 topics: political influence,
de autoridades
acting authorities, lack of participation of women in the judiciary, safety of infiltration by the organized crime, programs for protection of judicial officers, and instrumentalization of justice. And somehow the Inter-American Commission has expressed itself by several press communiques related to Peru, El Salvador, Mexico, Nicaragua, Bolivia, Colombia about these topics. And in this spirit of conversation and dialogue, I would like to say that because on the right-hand side of the table you have Claudia and the other Claudia. They mentioned something that in which we have to elaborate with you. You mentioned that the Commission could provide support on the processes of selection of magistrates, and within that logic of this work of the Inter-American Commission, I would like to know how would you imagine that contribution, that support that the Commission would could give. We are clear, and I believe that the Inter-American Commission is also clear in its report from, for example, in 2021, when it exposed to Guatemala in Chapter 24B, that independence, judicial independence, is one of the first symptoms it's one of the early warning elements when the democracy has been broken. So now, in this regional vision that we have, I would like to listen in this spirit of this conversation. How would you imagine this intervention that the Inter-American Commission on Human Rights could have within the spirit of technical cooperation, within our mandate, within an internal process of any given state? So I would love to know your perspective and your insights about this. Thank you, Commissioner.
Thank you very much. I would just like to conclude with a few thoughts and to then open up for a subsequent dialogue. First of all, I'm very grateful for the information about Costa Rica. It is one of the countries of which I'm rapporteur, and I would certainly ask if you could send that information in writing so as to take any appropriate measures, and also with respect to other countries for which I'm rapporteur, and will proceed as appropriate in the Commission. I think there are some things we all agree on. First of all, in order for this idea of there are still judges in Berlin to hold, I don't know if you know the story about the miller of Sanssouci and Frederick II, who what he wanted to do with his mill. And at the end of the day, he said, you can do whatever you want. You are the one in government here, but there's still judges in Berlin that protected him. And for this to happen, there are certain institutions that need to be maintained. First of all, the principle of natural judge must prevail. That is to say, the rules need to be, for the judiciary, need to be put into the Constitution and the laws, and those laws need to be followed to the T. And not necessarily, they should not be tried to somehow be accommodated. Plus, there has to be physical protection for the judges and their family members. Someone has said this who was living under threat for some time while serving as judge. Third, there need to be labor stability rules that must be unchanging. Fourth, there needs to be sufficient financing of the judiciary. That is to say, the governments, the legislatures can't use the budget as a weapon of war so as to influence judicial decisions. And fifth, there can be no incentive or disincentive for violating the principle of the natural judge or judge with jurisdiction, for example, attacks to try to influence judicial decisions, or the magnificent conditions of early retirement that judges may enjoy. Such measures should not be tolerated at all. I think there is agreement on this. Now, I think that Commissioner Caballero has put some other more problematic aspects on the table on which there are some clashing principles, and it would be very good to try to draw out some ideas or to put some ideas on the table or for us to begin a dialogue in this regard. I see that there is tension between, first, how to combat judicial corruption, which does exist, with non-criminalization. That is to say we have to pursue judicial corruption, yet at the same time we don't want judges to be criminalized, even though there may be cases in which they eventually may be corrupt. So that's an initial tension that I see that needs to be resolved somehow. A second point is, well, I understand meritocracy. I am someone who defends meritocracy in the judicial function. It's of great importance, but I also understand why the constitutions design procedures for selecting high-level judges and prosecutors where the executive or legislature may have some input or impact so as to create some sort of political sensitivity in those judges or future judges. And I say this with total transparency. I was a member of the Constitutional Court of my country, and perhaps one of the biggest lessons that I've had as a jurist was an entire month during which I sat down to speak with the senators, and I could understand many of the realities of my country without which I would not have been able to have served as a judge or do my job as a judge. We don't want a judge in a bubble either, who simply knows all the books by memory and can recite them. The co-optation system, I don't think that's the best, where the judicial bodies isolate themselves from the whole world and then elect their peers. I don't think this is healthy either. You can't say necessarily that there is politicization of the justice system because the Senate might be involved in the confirmation of judges nominated by the president. I don't think we're talking about that. What I think we're talking about is undue interference by the executive or by the legislature or by private groups in the content of judicial decisions. And so how can one preserve the judge there? I know there are self-preservation strategies, but there are also very hostile environments in which judges cannot preserve themselves. So I just wanted to share these ideas with you. And now, if we could open it up to a conversation. Thank you so much. And now I give the floor once again to the civil society groups. And let me look at my script. It says it's for 30 minutes. Thank you very much, commissioners. I'd like to respond to some of your questions, and thank you for putting these issues on the table. Before we put our petitions, I think there will be a relationship between the two. First is the question by Assistant Executive Secretary Jorge Mesa as to whether or not there are selection methods that go directly against treaty requirements. We do think there are some models that are not in keeping with treaty obligations, for example, those that are purely political, that leave it only solely to the political actors or some combination of them to choose the members of the high courts. That we should have if the pre-selection processes are also, which are technically oriented, are in the hands of political persons, then there's a high risk that they cease being technical. So these technical processes need to be out of the hands of the politicians. They doesn't armor them completely. They can still become politicized, but if they're in the hands of the politicians, then there's a greater risk, and a greater risk that these decisions are going to be considered non-justiciable political decisions, and therefore that cannot be reviewed when they violate the laws. Closed competition by invitation, I think, also run against the right to exceed public office in equal conditions. We need to reflect about the 3-person slates or 5-person slates that are closed. This is not a totally prohibited mechanism, but if there's not some way of having access or some way of reviewing who is on those short lists, then I think that that does tend to violate rights. The second question that I'd like to answer is the question by Commissioner Caballero as to whether we should begin thinking of affirmative measures as a general rule. Indeed, there's a great debate among the movements and among feminist movement whether to go with quotas or without quotas. But beyond that, our position, and here I'm speaking not only on behalf of DPF, but also Women for Justice, beyond the decision that is made, the issue of women's participation in justice systems is not quantitative. And it's not resolved merely by having more women on the courts, because that is simply attacking the symptom, but it doesn't affect the institutional frameworks that allow for that gender inequality. And so we need to go back to this issue in a more integral manner and not just reduce it to the issue of quotas or no quotas. Finally, I would like to refer to our petitions, and I don't want the time to go by without referring to them. First, we think that the standards on the selection processes are insufficient. We think they not only need to be deepened and developed based on the principle of judicial independence, because that's a very vague principle. There are other rights that come into play here as well, and that have yet to be developed, such as the right to political participation in public matters, the right of access to public information. There are other articles of the Convention that support that, the right to an effective remedy, Article 25, as well. So we ask that the Commission go forward in that direction through 3 measures. The first is prioritizing the advance of petitions related to selection processes and gender parity. Second, even though it's not immediate, but one should present a request for an advisory opinion before the Inter-American Court regarding the content of the guarantee of an adequate selection processes. Third, there should be an update of the thematic report of 2013, Guarantees for Independence of Justice Operators, to include new issues and challenges in the selection processes. And finally, that a public pronouncement be issued advising against political interference in selection processes. Second, we believe that given how central judicial independence is for the defense of democracy, we think a thematic rapporteurship should be created to address judicial independence and democracy. And third, that the Commission continue convening thematic hearings and country hearings to get information about other challenges that have not been addressed here, but that are also relevant, such as guarantee vis-a-vis outside pressures, the situation of freedom of expression of justice operators, and the right of association and assembly thereof, among others. Thank you. We know that without judicial independence, there is a risk for all of the population. That's why we reiterate the call to the Commission to issue the Ana Vilma Diaz and others case, the merits report in that, and that has to do with interference in selection of members of the court. This is an opportunity to break the vicious cycle of institutional co-optation and to rescue justice in Guatemala. I believe that the Commission could establish an international oversight mechanism from the outset of the process, establishing that those who participate in the process from the formation of those committees or commissions should be honest persons with no conflicts of interest when it comes to participating in the selection of judges. This is a very important moment because the designation of the committee members is just as important as the designation of judges. It's often been shown that they answer to sector-based interests that are interested in co-opting the institutions in order to maintain impunity and corruption. I think it's important to establish guidelines for a meritocratic, transparent process, free from undue influences, and to make sure that the persons who participate as candidates are suitable persons with necessary competences to serve adequately on the judiciary. It's important to have an on-site visit as soon as possible and also to provide technical assistance to the nominating committees so as to really change the process in which elections unfold. Finally, I would indicate that in the Guatemalan case, it's not that there's a tension between criminalization and the persecution of corrupt judges, but rather there is criminalization as an arbitrary abuse of the criminal law. My name is Alejandra Anabela of Sejil, and I'd like to take a couple minutes to provide a little bit more information about Costa Rica in view of the important challenges in naming the members of the Supreme Court of Justice. In Costa Rica, the process, in effect, is essentially political. The principal judges are elected by the legislature after they've been selected by a legislative committee. The legislature also elects the alternate judges based on lists sent by the Supreme Court. The main problem is the lack of regulation of the pre-selection process done by the nominations committee or appointments committee, which leaves broad margins for political discretion. And some elements of this discretion are, well, first, every time there's an opening, this committee decides what the procedure for evaluation and selection will look like. It might vary from one process to the next with no objective criterion. Second, there is no standardized profile in keeping with the specialty that would make it possible to compare the different candidates. Third, the vote of the committee is not reasoned. Finally, the greatest opening for discretion is the interview, which in the latest processes accounted for 60% of the total score. That interview is not structured, nor does it include predefined objective parameters. This high margin of discretion has a negative impact on the legitimacy of these appointments. The situation is all the more opaque for the alternate judges, for neither the court or the legislative committee assure an objective selection. So we urge the Honorable Commission to urge the Costa Rican state to regulate the process of nominating and electing these judges in keeping with international standards and constitutional principles of suitability and transparency so as to reduce the margins of political discretion and move towards the appointment of suitable persons who will guarantee the right of persons to judicial independence. Thank you very much. Thank you. Quite quickly, I would like to specify two elements that we wish to note. First, not all the countries have developed judicial career service. That is to say that one can't look at the case of Venezuela. There is no judicial career service or rule of law. That cannot be compared to a country with a well-developed judicial career service like Colombia and other sister countries. So one must distinguish between the two. And, for example, in the case of countries like Venezuela, one should note that there should be a judicial career service. The basic parameters should be laid out so as to decide for deciding whether a judicial career service exists, and this way make sure that people who are outside the judicial career service go to the high-level courts. So this is the problem. Some people go to the high courts because even though they've never walked into a courtroom. Finally, there should be indicators for judicial performance. There are for how to select judges, but not for how judges are evaluated. And this is something that should be considered. How many judges act against power? If the answer is positive, then we have a judiciary. If the answer is negative, then there is no judiciary. Thank you. Good afternoon once again. Sofia Bautista, Colombian Commission of Jurists. We've advocated judicial independence, protection of high-level officials, and the adoption of measures to guarantee the proper functioning of the administration of justice. In Colombia, the call to the election of the Attorney General by the Commission was presented by, or was depicted by some former presidents and former Attorney Generals as outside interference, but we think just the opposite. It's a call that says that the person who heads up criminal investigation should be chosen independently. Therefore, what we ask for is that no further barriers be put in place of the election. We support the appeal made by the Honorable Commission. We are of the view that the measures that can be taken are to oversee the objective criteria that are with which these elections go forward. That consideration, such as a person's gender, not be a criteria for dismissing the entire slate. Therefore, we ask the Honorable Commission to follow up on the procedures from the convening, the drawing up of the list of persons eligible and the election, as well as the appointment by high-level courts, or at high-level courts. Thank you. Thank you, Ariano Roca of Latin American Federation of Judges. Our organization calls on the Honorable Commission to reflect in its new report the good practice for protecting judicial independence and to discuss the implementation in the states of protection of judicial independence, which is contained only in Panamanian legislation at this time, nowhere else in Latin America. In addition, we ask that special attention be given to protection by having a special mechanism for protecting those who head up the associations of judges and prosecutors who defend judicial independence, who in many cases are persecuted. Also, considering that last year a hearing was held right here at the Inter-American Commission with judges on the same topic, judicial independence, we ask that bilateral meetings be scheduled with the countries that participated, all the Central American countries, plus Uruguay and Bolivia. They're all in need of follow-up and monitoring. And also, we ask you to urge the states to implement effective measures to protect the physical integrity of judges and prosecutors and to guarantee the lives of these judicial officers. Now, in the few seconds that remain, I have to say something about what Andrea Pochak, Commissioner, said, and what Commissioner Caballero said about the systems for selecting judges. Underlying this is a debate that's not begun in any of the countries, which is governance of the judiciaries and what are the competencies of the Supreme Courts of Justice, which are so attractive for the political systems, such to the point that they're always wanting to co-opt them. What the Supreme Courts of Justice have done generally is govern justice and not govern the judiciary. We understand that justice is not governed. Justice is administered. But what the Supreme Courts of Justice have understood is that it is governed. And through that, they have competencies which are election of the Attorney General, election of judges, of other high-level courts, other judges. So they have the entire judicial career service on their power, and they don't want to let go of this. And in each country, the high-level courts enjoy the least legitimacy because of so many situations that we're all familiar with. So the first thing is to begin or institute an honest debate about the competences of the Supreme Courts of Justice, and I would hope that it can be done through this commission. Thank you very much, Maria Dolores Vina of the Observatories of Rights and Justice, Ecuador. I'd like to take advantage of the second opportunity to talk about another issue which is of special importance to my country, which is selection processes for the high-level courts and oversight bodies. By constitutional mandate, these processes are done through what are not properly called competitive processes. This has not stopped political manipulation of these processes to support candidates who have clear political agendas or are not suitable, because the clear rules of the process are not incorporated into the statutes, but rather they're in lower-level instruments that are changed whenever as per caprice, as each time there's election. And this was seen when they were in the most recent partial renewal of the Supreme Court, which began in the last quarter of 2023. This process was had any number of irregularities, such as an impediment the Judicial Council considered that the information in the personal files was not public information. There was also a test that was done digitally, and certain mistakes were made that were never clarified to the citizens of Ecuador. Some of those nominated complained that there were arbitrary assignment of scores to others. There were also others with clear political interests who were weighing in. In the latest proceeding, only 32% of the nominees were, once it was suspended, were women. And as far as we know, the representation of ethnic minorities or racial minorities was not guaranteed. In this context, the International Observer Mission, made up of independent experts, alerted the community to these incidents, and as a result of pressure brought to bear by civil society, the competitive process was suspended in December of 2023. It is expected to be resumed or renewed in the next 2 months. Nonetheless, the new regulations that were issued by the Judicial Council do not appear to overcome the structural problems that have been mentioned earlier and which stem from regulatory provisions that are constantly changing. In this context, we ask the Honorable Commission to closely monitor the selection process for the National Court once it resumes, but also there are other processes scheduled for 2024 and 2025 that include the process of selecting the head of the Attorney General's office and the partial renewal of the Constitutional Court, that in 2025. In addition, we ask that the Commission urge the Ecuadorian state to adopt statutory instruments to give transparency to these processes. We also ask the Commission to grant a public hearing to specifically address the problems of judicial independence in Ecuador in light of the irregularities in the selection processes, but particularly in light of the growing influence of organized crime. Thank you, and I now yield. Thank you. I am Lawrence Pantin of Mexico. I'm going to round out what my colleague Marisol said about the constant attacks on judicial independence, which have taken on many forms in Mexico beyond the recent reforms pushed by the president, which bring an end to the judicial career service, which has been constructed over the last 25 years in our country. First are the accusations against the judiciary and specific judges, which have intensified to the point of becoming systematic when there was a change in the president of the Supreme Court last year. Since then, we have identified 165 public statements that say that the judiciary operates on the basis of watchwords and that it frees criminals. 88% of these statements have been made by the President of the Republic. As a result, there have begun to be threats against judges. This has resulted in physical attacks, some of which have been mortal. From 2012 to 2023, there were assassinations in unknown circumstances because they've not been investigated, or that suggest it could be because of their position. 6 non-judge officials and 17 judges. Also, there have been the impeachment proceedings have been used against judicial authorities. In recent weeks, the executive presented a request for an impeachment against a federal judge, and just days later, legislators from the majority party announced that they were preparing another impeachment proceeding against a member of the Supreme Court. The efforts to subjugate the judiciary at the federal level have been replicated at the state level, criminalizing judges. This happened last year with the arbitrary detention and disappearance for a few hours of a judge from Veracruz. Another way to undermine the judiciary is to politically capture the highest level positions with the designation of members of the court who are either close to the executive or who are actually activists in the governing party. So instructions are given by the political powers to judges, and if they don't act accordingly, they can be subject to sanction. We ask that the Inter-American Commission prioritize judicial independence in its agenda regarding Mexico. Thank you very much. Next, we are going to note some of our key petitions for the case of Peru, mindful in particular that several judicial officers have characterized the current situation as, indeed, a situation even worse for the judges and prosecutors than the situation during the Fujimori dictatorship of the 1990s. First, we ask for the urgent monitoring and a pronouncement by the Commission regarding the supranational standards that Peru should respect vis-a-vis the imminent removal of the National Justice Board and the intervention of the Attorney General's office. Second, consider including Peru in Chapter 4B of the report by the Inter-American Commission, as it is a country that requires urgent and special attention, just as Guatemala, Venezuela, and Nicaragua are receiving. And finally, we would like to ask that in promoting judicial independence in the Americas, the Commission should especially consider the role that journalists and civil society organizations play, particularly when they are threatened and subject to violations for promoting investigations or promoting judicial independence. Thank you very much. Thank you very much. In the second round, in addition to the two petitions we put to you in the first round, we would like to refer to judicial independence. While it is true that the judicial developments of the countries of the region are different, there is one factor in common, which is that, for example, in Bolivia, the budget of the judiciary depends on the will of the executive. There is no economic independence. And the first independence there should be is economic independence. You have an excellent opportunity. You have yet to present the report of your on-site visit to Bolivia, where you were able to see the calamitous situation in which judges and prosecutors work. Just one piece of information: 1,400 judges for all of Bolivia, who receive each year an average of 380,000 new cases. You can do the calculations to figure out just what that caseload is for each judge. It's impossible. In addition, it's necessary to establish standards for evaluation of judicial performance, and that should be common for all of us. And above all, the accompaniment and oversight of the Commission in the electoral process, which now is reaching its end. Thank you very much. Maximo de Jesus de Flores of Argentina. First, I'm going to make some proposals that I think are in keeping with what the commissioners and the colleagues from the various organizations have mentioned, and then a few particular comments. Flores brought 4 proposals for the Commission. First, to undertake more rigorous monitoring of the Inter-American Democratic Charter regarding the separation of powers and judicial independence. Second, that one insists that the judiciaries focus on seizing the proceeds of corruption. Third, that one deepen the relationship of independence to judicial independence, corruption, and poverty. And fourth, there should be a greater participation of civil society in these matters. This hearing is very positive, yet at the time that has been assigned to us doesn't correlate to the importance of the issue of judicial independence. And so here I refer first to what Commissioner Caballero proposed, which is to have a more in-depth dialogue. We have thought about having a seminar or a conference where civil society, the judges and members of the Commission could debate various issues related to judicial independence. Tied to the judicial resistance that Commissioner Pochak had mentioned, or judicial corruption, which Commissioner Bernal mentioned, I agree that has to be part of the debate. It seems to me that it's difficult to propose that debate when the judiciary is under attack. That's a major difficulty for the judiciary to open up. One of the problems of judicial culture is conservatism. I don't know if I agree so much with judicial career service. I think that is a topic that can be debated because as Commissioner Mesa depended, that depends on whether you have intrinsically bad systems. Each region has its customs. The continental European-based system has the judicial burden system, but not the common law system. The U.S. In the U.S., the president appoints and the Senate confirms. So in theory, there is just one political instance. It seems to me that in the region, after hearing from my colleagues, the big problem is politics. If you leave a small space for politics, then there's like a metastasis, and it expands and thereby has a negative impact on judicial independence. So therefore, I think we need to pick up on the experiences and culture of each of these regions. So it seems to me, well, the conclusion I draw, and this might not be shared by everyone, is to bring about a debate. This is a very important position that the civil society conveys to the Commission, but I think there needs to be a second step, which is what do we do with everything we've done today? And our proposal is to have a wide-ranging debate among all of us who are involved, justice, civil society, and the Commission. Thank you very much.
So I'm going to take advantage of the fact that we still have a few minutes to answer some of the questions brought by our panelists today. I think that regarding the models of election, I would be inclined to go with Ursula. I mean, there are models that are not admissible, and those are the ones that participate at all the political influences in the appointment of judges. I would also say that the models of popular election, even if they are valid in some countries, they can generate serious troubles. A judge, male or female, can never be subject to the will of the majority, because El Salvador is the best example of how, at some point, the will of most of the population goes against the human rights, and they are going to. This is a problem. So I believe it should be an autonomous, permanent commission that guarantees the career. The career is the minimum standard for citizens to be able to enjoy the independence of our judges that will guarantee our access to justice. And I would like to also answer the question that was asked by the Executive Commission in the important election that we are having soon in Guatemala for all Guatemalan citizens and for the region as a whole. The voice of the Inter-American Commission is fundamental. This is a voice that can be expressed, and I highlight the relevance of this visit, if a visit is possible. So I would like to listen to you in the country about how that process of election should be conducted. As Claudia mentioned, not only the work of the officers, but the appointment of the commissioners, and for example, those who are being, the candidates cannot be at the same time, they cannot nominate people and cannot be nominated, because that paves the way for trafficking in influences. And also, in a communique, the Commission offered Guatemala and the different institutions of the Guatemalan state technical assistance, in situ assistance for this Commission. That would be very important. 2 minutes are left. I don't think if somebody else wants to say something very briefly. One of the topics we have not discussed is the topic of the legal management. The times of justice are also important. In second place, I believe that maybe appointing someone who does not belong to the justice world will help us. Maybe the appointing of any person would have to comply with two requisites: being competent and being decent. But within these two conditions, we can appoint people from the justice field, or maybe lawyers. Yes, I just wanted to take advantage of the minute that we have left. We believe it is very important that the Commission works jointly with the Special Rapporteur for the independence of attorneys and lawyers in countries that should be a priority. There are countries that are basically hanging from a thread. Guatemala, Peru, Bolivia, Ecuador are just some of them, and within each country there are specific topics. So maybe we could have this coordination and joint statement. That would be something very useful. Thank you. Well, I don't know whether my colleagues want to say something. I am a university professor, and I know that we can, as we say in Colombia, there is a limit to our understanding here. We are starting to feel tired. So this idea of the seminar is a great idea. This is something that will be interesting for everyone. Well, thank you so much for this honest and frank dialogue. I would kindly ask you to send you the information. Thank you, Margaret. And, well, thank you so much. The meeting is adjourned.